for the
I am for the applicant.
appellant.
Application for contempt. But I am filing my affidavit of reply upon service to all the others.
Yes.
For the alleged
Your
contempt.
lordship, well, my lord, initially, my lord, there was a direction to pay 50 lakhs for, my lord, the alternative accommodation.
Yes.
Now, my lord, they preferred an appeal where, my lord, it was reduced to 25 lakhs. That amount has not yet been paid. My lord, your lordship had directed the affidavits to be exchanged, my lord.
Unauthorized construction.
Yes, my lord, construction has been substantially demolished. Only 2 old lady persons are
Oh,
staying.
these are the ladies. All right. Then what happened? They are still there?
Yes, my lord, they are still there. That's why the remaining work could not
Cannot be done.
Now, my lord, kindly see today the applicant has filed a exception. Of the
Exception?
Yes.
Dekhi. Exception to what?
Exception is not a reply.
Reply, my lord. They have filed an opposition, my lord. Your lordship
They
has
have
granted them
the contender filed opposition. They have filed
as to
reply.
why they could not pay the amount of 25 lakhs, my lord, explaining the reasons.
All right.
Now, my lord, kindly see.
Is this the construction?
No, this is not the construction. That is the additional asset.
To exception is owned by this contender.
I really fail to understand. My learned friend is appearing for the corporation.
Yes, yes.
Let my learned friend applicant place the case.
No, that is there already possibly. Otherwise, how will the corporation get to know?
That is my lord. I am also my
Yes.
Kindly see at page 8 of that particular affidavit in reply. Kindly see the last 4 lines.
Yes.
I say that the alleged contender is a developer and constructed several buildings in the locality, including 131 Kolimuddin Sarkar Lane, which is a sanctioned G+3 story construction, and where he resides with his family members, standing in the name of his family members. And another one at 1/H/3 Kolimuddin Sarkar Lane, which was constructed and subsequently sold by him to different purchasers. That means apart from the disputed premises,
there are other premises also.
That is the which does not have a building plan sanction. The Council Authority of Kolkata Municipal Corporation, G+3 story building at 31 Kolimuddin Sarkar Lane has several unoccupied flats and possibly waiting to be sold to the intending purchaser. That this fact was never brought to the notice of either this honorable court or notice of the honorable division bench. This is one of the facts. The second is, my lord, when this particular disputed building was constructed, the contender filed an affidavit for your lordship at court number 24, wherein he has expressed that he received 86 lakhs from some of the flats which have given to third party. Where is that money? And nothing has been explained how those money has been spent. And Mala, kindly also see their affidavit in opposition at page 87. Your lordship will.
There means whose?
These contemners.
All right.
At page 87, your lordship will please to find that they say that he is engaged in Rapido business. Rapido. But can you see these business is running for 4.4 years? That means 4 years, 4 months. Not before that. So this person was engaged in constructing the building prior to that, including this disputed building, and this business is a side business. So that this person has money, can give it or give a separate accommodation so that the corporation could enable to
demolish,
execute the remaining part.
All right.
And those 86 lakhs where it has gone, nothing has been explained in this opposition.
Yes, contender.
My learned friend has placed the case, my lord, for the petitioner.
Not for that. Whatever, maybe the corporation has a duty.
My lord, first of all, my lord, I'm just answering, my lord, one line, my lord, what my learned senior friend has placed. My lord, this is not the fact. My lord, this is mere averment. No document is annexed with the affidavit in reply. My lord, I have not constructed, apart from this building, no other building. Let my learned friend show a single scrap of paper before your lordship, I will be out of court.
Why are you not complying with the order passed by the honorable division bench?
My lord, I am coming. My lord, I have 2 fold of submission before your lordship today. My lord, first fold of submission, my lord, this contempt is not maintainable before your lordship. Number 1.
Why?
Number two, my lord, I have not violated your lordship's order willfully and deliberate. my lord, first of all, your lordship, my lord, if your lordship take up the, my lord, contempt petition, my lord, this contempt petition, my lord, the order passed by your lordship, my lord, 22nd May 2024.
Page.
My lord, contempt petition, my lord, your lordship's order.
Page 39, your lordship. Not page 39.
Yes. No, 39 is
But
division bench's
35.
order.
No, my lord, I'm just, my lord.
10th April 23.
22nd May 2024. This is the
Page
order.
35. Page 35. It starts from page 36.
Page 35 is 10th April 23, I can see.
No, my lord, I'm just, my lord, where your lordship's, my lord, directed to, my lord, pay of rupees, my lord, 50 lakhs.
This is page 35.
22nd May, it's 59.
22nd May, my lord, page 59.
Yes.
My lord, this is the order of 22nd May 2024.
Hmm.
My lord, your lordship kindly see the contempt was affirmed. My lord, July 2024,
Yes.
23rd July 2024. My lord, your lordship, this, my lord, against the order, my lord, the appeal was preferred, mandamus appeal. My lord, the appeal court, my lord, passed the order, my lord, 7th October 2024. My lord, your lordship, my lord, I will, my lord, invite your lordship, my lord, kindly, my lordship, take trouble to, my lord, come to my affidavit in opposition. My lord, I have filed. My lord, I have annexed the, my lord, order
Yes.
of 7th, my lord,
7th October 2024. 7th October,
7th October.
page 13.
My lord, your lordship, kindly, my lord, come to page 13. Madam, just, my lord, this very, my lord, small order, my lord, I'm just reading, my lord. The court, in spite of repeated opportunities, appellant has not been able to arrange for alternative residential arrangement to the satisfaction of the private respondent. It is contended the private respondent are raising flimsy and untenable objection.
Hmm.
In such view of the matter, my lord, kindly note, we modify the order and direct the appellant respondent 11 shall deposit a sum of rupees 25 lakhs with the Registrar General, High Court, Calcutta, accommodation to the respondent number 13. My humble submission before your lordship, my lord's order, when was, my lord, carried to the appeal court modifies the order. My lord, the order, when your lordship, my lord, knows, my lord, is settled principle of law. When the order modifies and, my lord, merge with the, my lord, the appeal court, my lord, the contempt or execution lies before the, my lord, the
Division bench.
division bench. My lord, my submission, my lord, after this order, my lord, the first limb of submission, my lord, your lordship's order dated 22nd May, modified by the division bench. So therefore, any execution or the contempt or the review, anything lies before the division bench now. My lord, on this proposition, my lord, it is, my lord, well settled principle, my lord, for the satisfaction of, my lord, mine, my lord, I, my lord, show your lordship, my lord, the, your lordship, my lord, invite, my lord, I can, my lord, cite, my lord, 2-3, my lord, authority. এইটা আরেকটা অর্ডার কোথায় ম্যাড্রাসে এইটা এটা ম্যাড্রাস তো না 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 এগুলো সব সুপ্রিম কোর্ট দেখাচ্ছে হাইকোর্ট এটা কোথায় এটা কি পেটন নম্বর এটা কত নম্বর ইয়ে
মনে হয় এখানে
হুম
8 নম্বর
এটা কি হবে সেকেন্ড স্টেপ
Has the costs for demolition been paid?
Yes, madam. 2 lakhs have been paid.
That has been paid. All right. But you are unable to demolish it because of the ladies over there.
Yes, partly demolished upper portions.
How many floors?
There are 4 floors.
And how much have you demolished?
1.5 floor part.
1.5 floor is remaining. The ground and the
Portion of the first.
portion of the first floor.
No, but my instruction is that entire thing has been demolished. Only one room is left for the ladies to stay there.
One
Only one
room
room in the ground floor. Yes, that is my instruction.
is left for the ladies to stay.
This is demolished. Yes.
All right. Do you have photograph of the construction as
I
it
can
stands
bring
today?
I can bring it. I can bring it. I can produce before your lordship on the next.
Please bring the photograph. I want to see what is the position of the
For the next
construction
day.
now. Have you followed? And you see what is to be done with those ladies, because the one room, it is enough leniency have been shown. Now nothing can be done. The order is dated May 24, right? So nearly 1 year will be over within a few months. Try for alternate accommodations and see what can be done. I'll hear the contemptor on the next day. I want to see the photograph of the structure.
But I have one submission, my lord, to the contention of my learned friend. This doctrine of merger will apply, my lord. This order has merged with your lordship. Previously, when the division bench was
We'll
the appeal-
consider this on the next
Yes.
day. A reply. What was filed today? The reply. Affidavit in reply
And my lord, one more issue.
by the
But, May I make one more submission before your
applicant.
lordship, my lord?
Who is this person? Applicant? Naki? By the petitioners. By the petitioners. Be written on record. Stop. Learned advocate for the petitioners is directed to produce copy of the photograph of the disputed structure as it stands today. The photograph, the photograph shall be such so that the court can see,
Yes, it
not
should be a A4 size photograph.
no, it can be small also, there is no difficulty, but at
Yeah,
least it can
clarity.
be understood as to the height,
Yes.
the length and breadth of
Some
the building.
distance to be taken.
Yes,
that it is
otherwise
apparent.
you bring only 2 bricks, the court will not be able to
It will be
follow
apparent from the photograph. It will be
where she is staying. And
She's-
if you have the previous structure also, then that will be good.
previous structure will be difficult.
Very well, if you can. Maybe corporation must be having some records to show
Well, I'm
Please
taking
check up.
instructions with that.
what it was and what it will be. Make arrangements. I'll see what is to be done. When?
My lord, one more submission I have. My lord. This,
Yes.
Even though, my lord, your lordship's order in the last paragraph, my lord, mentions that, my lord, immediately upon the end of the month, May 2024, it will be open for the corporation to start the demolition work. But this part of the order is not complained of in the contempt petition. But any order passed, my lord, will be supplemental to the, my lord, the order originally passed. Now, in the contempt jurisdiction, my lord, I put the question to myself whether such orders can be passed because the writ petition is
Which
still
order?
pending and alive. Any further order for
The
demolition
writ petition is still pending.
is still pending. That
All
is the
right.
contention. That the prayers, my lord, made by the corporation can be made before the my lord, court taking the writ petition, which is dealing with the demolition of the structure. That is still pending and alive. Whether in
The
this
writ is not
instant,
disposed.
that is not disposed.
Not
And
disposed.
whether,
It's
my lord, in
against
this-
the interim order, my lord.
It is against.
whether in the contempt
And after completion of this contempt proceeding, the matter may be made.
matter may be heard. So whether
All
or not
right.
any supplementary order can be passed in the
All
contempt
right, all
jurisdiction
right.
is my contention. Your lordship will kindly
Very
consider
well,
that.
very well. Next day.
Agreed.
When? 5th of March? 2 weeks time?
Yes, madam.
Yes, 5th March.
My lord, I came to my lord, kindly fix this matter day after tomorrow because my lord, Special Secretary and Competent Authority under West Bengal Apartment Ownership Act, they are the main party here in my lord. My lord, I found that service is not complete. So my lord, kindly fix this.
Who did you serve?
My lord,
My lord, I am appearing on behalf of the competent authority, my lord, but
Yes.
the
Yeah, my
submission
lord,
made by my learned senior friend, my lord, is correct, my lord. They do not have the copy of the
no, my lord.
application, my lord. They have told me, my lord. I asked them for the instruction. They said they do not have the copy of the brief, this case,
Yes,
my lord.
How
Let him
how
come.
come you are appearing? If the copy of the application is not there,
They serve to the office of the AOR, my lord.
right? So your client will collect it from there.
But the AOR, they gave me, they engaged and gave me the copy, my lord. But the department, the concerned department, the competent authority, they do not have the copy of the application, my lord. I have
Please
to send
tell
it to
them,
them. They will
please
serve,
tell
my lord.
them to collect it from you.
My lord, my lord. Kindly grant 2 days time, my lord.
Then, my lord, tomorrow.
There
my
are
lord-
private respondents also.
Yes, my lord. They have
Three-
refused. We have the affidavit of service. All of them have refused.
3 to 9.
Yes, my lord. All of them, they have refused.
All of them have received. Item delivery refused, I can see. Item delivery refused.
All the office bearers.
All are refused.
Yes, my lord. Because, my lord, election is fixed on 23rd of February. My lord, they knew that we are coming before your lordships. They, after knowing the fact, my lord, they have refused.
You are challenging some election.
Yes, my lord. The procedure, how the election was organized, that is not legal. That's why the order passed by the competent authority we have challenged, and we are before your lordships.
Mr. Farmania, 23rd is
My
the
lord.
election, 23rd is Sunday. So you need to come back with instructions immediately. Please
My lord,
forward
second-
soft copies to your client so that the instruction can be forwarded. I can fix it up tomorrow.
Tomorrow, my lord.
my lord, my lord. I
Grateful.
shall do it.
To allow Mr. Farmania, learned counsel representing the competent authority to come ready with instruction. List the matter tomorrow.
Grateful, my lord.
I'll do a brush, my lord.
I'm for the, I'm
My lord, we are not serving the copy then, my lord. Grateful, my lord. Grateful,
If you want to serve additional copy, it is up to you.
My lord.
But then I have requested him.
my lord.
See, it is always for your
Grateful,
benefit if you serve.
Grateful, my lord.
Lord, I appear for the petitioner, Lord.
Yes.
Lord, this is an application for writ application filed for non-payment of dues by the railways.
What work did
But
you
the
perform?
final bill, security deposit, GST and a calculation mistake, that's all. Total amount was 22 lakhs and all. Now, after we filed the writ application served on them, what they've done, they've transferred the final bill to my client's account.
They have
Remaining only
transferred.
the security deposit and about 7 lakhs and odd is remaining. If
Yes.
an infant takes a instruction or is agrees, Lord, she could direct for the
Security deposit and
security deposit, GST and some calculation mistake.
all right.
Total amount comes, that's a very small amount.
Please come.
48,000. Total is 7 lakhs and odd maybe.
Due.
Due. And on miscalculated, maybe 7.5
Uh,
lakh.
The petitioner alleges non-payment of the billed amount, including security deposit, GST adjustment for the work performed as contractor. Stop. After filing of the writ petition, it has been submitted that, a portion of the payment has been made. Stop. According to the petitioner, approximately 7 lakh and odd is due and pending on account of security deposit, GST adjustment and certain calculation errors. Paragraph. Learned advocate representing the respondents is directed to take necessary instruction. List on 5th of March. 2 weeks time will be all right.
As motion itself, actually.
Yes. Court application.
Maybe on 4th or any other day, Lord.
Very well.
Some
6th.
problem.
6th.
6th.
I'm grateful.
Right.
Your Lordship, I'm appearing for the petitioner. I'm just praying for an accommodation because there is an appeal pending before the Chief Justice. It's running as item number 7 today in the list. It's most likely to be taken up, Your Lordship. So if the matter can
Appeal from what?
there has been order of Justice Shobashachi. So from there, an appeal has been filed. It's the same cause of action, just the bank is different. That is State Bank of India, and this is IDBI Bank.
On the prayer of the learned advocate representing the petitioners, the matter stands adjourned till 10th of March 2025.
Item number 5, my lord. I am appearing for the petitioner in this one.
What happened to the respondent?
What is the matter about?
Yes, my lord. Shortly, my lord, I recapitulate the facts. My lord, the petitioner is, my lord, the wife of the, my lord, deceased employee of the respondent company. Now, my lord, the employee died while he was in service. Now, my lord, as per the, my lord, policy or, my lord, the trust, my lord, created by the company, my lord, he was entitled to, my lord, while in death, if happens during the service, my lord, the 12-month salary, my lord, is, my lord, the amount payable by the company to the deceased employee against the benefit, death cum retirement benefit. Now, my lord, in this policy, my lord, we have applied before the company, my lord, to release all the death cum retirement benefit of the deceased employee. My lord, the employee's personal, my lord, has informed us, my lord, calculating 12 months emolument of salary, my lord, the figure comes to around 8 lakhs and odd. Now, my lord, the dispute comes, my lord, kindly turns to, my lord,
देखिए writ petition.
page
Opposition.
37 of the writ petition, my lord.
Yes.
Maharaj got page 37. Kindly takes up from the second paragraph of that page. As regards the contents of your email below, after referring to the related company policies and documents, we would like to confirm that the amount of rupees such and such that has been duly remitted to your bank account, in fact, forms the full amount payable as per the relevant act and rules of the company and the applicable Bamalori gratuity trust rules. We would also like to share that notwithstanding payment made already, we had undertaken a thorough and examination of the matter in case in higher amount stands payable. However, even after such detailed examination, it has been reconfirmed that the payment made is in full compliance with the relevant act and the company's gratuity trust rules. We feel extremely unfortunate that you had a different understanding in this regard. However, we are compelled to inform you the governing rules would not permit any additional consideration on this account. The organization has unintentionally and erroneously communicated to you the expected amount of rupees 8,55,048 as eligible gratuity. We deeply regret the mistake and the inconvenience caused to you. The Millard company initially informed us, Millard, of this figure. Then Millard company revert back to Millard 2 lakhs, saying that Millard that rule is not applicable to you. Whether rule was existent at the time, Millard, when this was communicated to us, and at the time when the employee died. Now, Millard kindly takes up the rule which we rely upon, Millard, and the company itself relied upon while initially communicating to us. Millard kindly turns to Millard page 54.
Yes.
Millard kindly takes up the relevant rules is 15.2 is as to gratuity, and Millard our case falls under 15.2.4. Now, Millard, in case of death, the amount of gratuity will be as calculated under 15.2.3 or as worked out below, whichever is more. So, Millard, in case of death, completion of 5 years, Millard, we are in the category Roman 3. Completion of 5 years, but less than 20 years of service, 12 months of emolument, basic plus DA. So, Millard, this comes to Millard 8,55,000, which was communicated to us. Now, Millard, they now fall back into rule 15.2.3. Now, Millard, they use an opposition before Millard in this court, saying Millard kindly takes up their opposition for once. Millard kindly takes up internal page 5 first of the opposition. The paragraph starts off that page. The first paragraph which starts, I say that clause 15.2.4 of the said Manual of Service of Terms and Conditions for Executives, which was attached by the respondent to justify her claim of the enhanced gratuity, was deleted in May 2022. Now, my lord, the death, my lord, occurred is on 26. Is on, my lord, 18th of May 2021, page 26 of the writ petition. So, my lord, as on 2021, 18th May, this 15.2.4 exists in the this manuals of service. This is admitted position by them. They rectify it or delete it in May 2022. Now, kindly turns to the next averment, which my learned friend would definitely rely. Paragraph E in internal page 6 and F. May I place those paragraphs, my lord? I say that the aforementioned amendment in the company's gratuity fund rules and regulations, which took place with the approval of the Commissioner of Income Tax and effective from 16 July 2013, happened much before the death of the petitioner's husband. Hence, the same was binding upon all employees, including the said late husband of the petitioner, and after his death upon his legal heirs. I also say that the company's representative had made an erroneous calculation of gratuity amount to the tune of 8,55,048, whereas the actual amount of gratuity is 2,46,648. The aforesaid erroneous calculation was made on the basis of the then unamended clause, marks these words, unamended clause 15.2.4 of the HR manual, which was subsequently rectified in May 2022 in the line with the amendment in the company's gratuity fund and rules regulations effective from 16 July 2013, which was duly approved by the Commissioner of Income Tax. I'll leave it up to this. Rest are not really relevant for the moment. So, the question, which falls for now consideration before is, and rule which was existing unamended, on the death, whether that rule would apply or the rule which subsequently is rectified, in May 2022, would apply. Now, this is a short question, of law involved in this. If
When was the gratuity paid?
gratuity paid, gratuity paid remitted on their, as per their calculation, if takes up the writ petition, this communication comes in 22nd June 2020, they remit 2,46,000.
Death is on May 2021.
No, my lord, in June 2021, they write a letter, which I have placed before my lord, where they say they have already remitted the gratuity figure to my client, which they calculated as per my lord amended provision. But the amendment takes it thereafter. Kindly takes up page 37 for once. The second paragraph which I have placed.
Say
As-
22nd June 2021.
As regards the contents of your mail, after referring to the related company policies and documents, we would like to confirm that the amount of rupees such and such that has been already remitted to your bank account. So, my lord, as on that date, 15.2.4 is there. And on that date, my lord, they remit that amount, and they, in the same letter, same breath, they say the figure which was communicated to you.
Where is this communication?
My lord, kindly turns to page 34. This is the gratuity amount communicated through WhatsApp. 34 to it. 36, sorry, my lord. 34, 36. This is 15 June 2021.
Yes. The person expires on the 18th
May-
of May
May
2021. Right. 15th June, you are intimated that 8 lakh gratuity will be paid.
Yes.
And then on 22nd June, they remit 2 lakh and odd and say that 8 lakh
Is
was
erroneous
wrongly
calculated.
Since June, we write a letter to them also indicating that the calculation was erroneous, and
That's exactly what fell from my lord. So, my lord, what fact remains, my lord, on that very date, the amendment has not taken place. So, my lord, on that basis, my lord, we filed this writ petition. In the opposition, they admit, yes, the rectification took place in May 2022 after a period of almost a year. Or, my lord, yes, almost a year.
Now, my lord, in this backdrop, kindly takes up, my lord, their opposition, my lord, the documents which they rely upon to substantiate their case. My lord, kindly remembers paragraph 8, if they say, in line with the amendment. Now, my lord, what is the amendment they rely upon, my lord, kindly takes up. My lord,
May I just clarify my case, my lord, before he shows. My lord?
No, he places it in his way. You'll get your turn. Please take your seat. Sit down.
First, I say, my lord, there is no amendment. In my respectful humble submission, now the document which they rely upon saying that it's an amendment. Kindly turns to page 37 of the affidavit in opposition.
Yes.
My lord, this is the deed of variation which took place, my lord, in the year 2013. Now, my lord, kindly takes up the first recital is important. My lord, I place the first recital. This deed of variation is made this second day of July 2014 by and between Bamal Lorry, an existing company within the meaning of Companies Act having its registered officer such and such of the one part, and Sri such and such and Mrityunjoy such and such all residing then, my lord, of the other part, supplemental to the trust deed dated 29th day of December 1975, executed by and between the company of one part and the then trustees of the other part, as modified by several deed of variation dated 11th day of November 1977, 20th day of December 1994, and 15th day of April 2018, herein after referred to as the deed of variation. So, my lord, there were three deeds of variation. Why I stress on this? Which, by virtue of which an amendment had already taken place in the trust rules. So, my lord, this deed of variation, my lord, is a decision of the company by virtue of which an amendment has to take place in the trust rules. So, my lord, it's not the amendment which has taken place. It's a decision which has been taken. Now, my lord, kindly first, whereas by the principal deed of gratuity fund called the Bamal Lorry and Company Limited Gratuity Fund was established as on and from the first day of April 1975 for providing retiring gratuity for the benefit of the employees of the company as defined in the principal deed, read with the rules and regulations of the fund. Then, my lord, by the deed of variation as aforesaid, my lord, it refers to the first cost title. Certain amendments were carried out in the principal deed and the rules in the manner to the extent therein mentioned. So, my lord, paragraph says those variations, my lord, which had taken place and amendments had been carried out. Now, my lord, 3. Under clause 12 of the principal deed, the rules framed thereunder, the trustees have the power, with the consent in writing of the company and subject to approval of the Commissioner of Income Tax having jurisdiction over the fund, to alter or modify or add to all or any of the provisions of the principal deed and the rules made thereunder. This is the enabling power they have. 5. My lord, I am skipping 4. 5. The trustees and the companies are desirous of amending the principal deed and the rules made thereunder in the manner and to the extent hereinafter appearing, and the said amendment have also been approved by the Commissioner of Income Tax having jurisdiction over the fund. So, my lord, it's a desire which is being, my lord, recorded in form of writing, my lord, in this deed of variation. Now, my lord, now this deed witness, in the exercise of the power vested in the trustees and the company under clause 12 of the principal deeds as amended as aforesaid, and of all or every other power hereunto, by enabling the trustees to hereby declare that the principal deed and the rules shall be amended in the manner and to the extent hereinafter appearing, and that the said amendment shall take effect as on from the 16th day of July 2013. Now, my lord, what will be the proposed amendment that is been cited? Now, my lord, the relevant proposed amendment which is referred kindly turns to internal page or of that deed, my lord. 7, rather, my lord, 8. 8 is, kindly sees, rule 11C2 and 11C3 of the rules shall be deleted. Now, my lord, pause here for a moment. I refer to what these rules are. They have annexed these rules with this opposition as well. Now, my lord, kindly turns back to page 22. My lord, this is the, my lord, I say, my lord, till date unamended rules which will be amended if they take steps. My lord, it starts from page 18 and page 22 is 11. 11 starts from page 21, bottom payment of gratuity. 11.3 at page 22. My lord has got it, my lord?
Yes.
Now, my lord, 11.3 says, notwithstanding anything contained in subclause B of Rule 11, in the case of death of a beneficiary under the category of officers, the amount of gratuity shall be calculated under subclause 2 above or as worked out below, whichever is more. My lord, C kindly sees is 12 months salary or wages. Now, my lord, what they rectify kindly turns to, my lord, page 13 of the opposition. In May 22,
What was his salary?
my salary was 78,000 and odd, my lord. Yes, 78,572. My day appointment letter, my salary slip also annexed.
78,000?
78,572. Well, that is including the DA. And salary slip, my lord, will find at page 27 of the writ petition.
All right.
Now, my lord, what they rectify in their opposition as they state, kindly turns to page 13.
Yes.
They rectify this manual of service terms and conditions for executives. So, my lord, this is not the page 18. It's a different thing. And by the deed of variation, what is sought to be amended is 11.3c of this rules and regulations, which is dated 28th of December 1994. This is the fund rules which needs to be amended. Now, my lord,
Page 13 is something else.
page 13 is something else. My lord, this is the manual of service terms and conditions for executives, which contains, my lord, page 17, chapter 15, which I also relied. Unamended portion, they relied upon the rectified portion, which is of May 2022. Kindly see 15.2.4. Now, after rectification, they say the amount will be calculated as 15.2.3. So, my lord, it's not deleted. Their language is it's deleted. It's there, but they write it in this fashion.
What is the role of the government over here?
My lord, Baman Lorry is a state, my lord, under Article 12. Is a there were lot of litigations on this, my lord, after this
Government company, my lord.
government company.
It's an undertaking now, or it's a government company?
Government company.
Correct.
The Ministry of Petroleum.
Yes.
Now, my lord, so therefore, gratuity fund rules is till date in the opposition. They say it's not amended, but they rely upon the deed of variation. Now, my lord, kindly turns to, my lord, that deed of variation once again. Kindly turns to, my lord, internal page 5 of the deed of variation. My lord, an amendment was desired to be taken effect, given effect of Rule 11, my lord, kindly sees 15, that is unpaid gratuity amount. The company thought fit, my lord, to rectify only with respect to the unpaid gratuity amount. So, my lord, by virtue of this, 15.4.2 was never touched. What was touched, my lord, is 11.11.3c and 11.3. 11C2 and 11C3.
But an unpaid gratuity account. This is
Yes.
an unpaid gratuity account.
Account.
It's a different account
It's a different.
altogether.
So, my lord, that's why I say or related to gratuities, what was sought to be amended is 11 C2 and C3 and this unpaid gratuity account in this deed of variation. So, my lord, in this deed of variation, my lord, after this deed of variation, my respectful humble submission till date, admittedly, my lord, the gratuity fund rules has not been amended. For the purpose of this litigation, they bring up the rectified clause in a manual.
Mm. Yes.
Now, my lord, if this is the scenario, given scenario, my lord, suppose, my lord, I take my case to a bit on the lower side, say that they have carried, tomorrow they say, yes, we have carried on the amendment. Now, even then, my lord, the date of amendment is subsequent to the death of death. Now, my lord, my respectful humble submission, unless an amendment is taken effect or given effect, my lord, it doesn't become an enforceable law. My lord, the law in force can said to be a law in force only if it is given effect or given into operation. My lord, this deed of variation is an intention which has been laid down by way of this deed. Operation would be given after the amendment takes place. Now, my lord, if this is the settled position of law, my lord, today I say on the date of death, the rule 11C2 existed. Even today it's existing. They do not produce an amended copy. Even if they produce, on that date it existed. And 15.2.4 was existing, my lord, admittedly rectified in May 2022. So, my lord, what was existing at my point of death, my lord, I would be entitled to that. Now, my lord, to support my argument, my lord, this is absolutely on point of law, my lord. I rely upon 1969 to SCC 340. Copy in it. My lord, kindly takes up paragraph 5. My lord, this was with regard to, my lord, and my lord, amendment taking effect in a statute vis-a-vis, my lord, the constitution. Now, my lord, kindly takes up paragraph 5 of that decision, my lord, the relevant portion. My lord, I rely upon paragraph 5. May I place, my lord?
Yes.
Before the High Court, it was argued on behalf of the landholders that when the Principal Act was enacted, it became law in force, and the ceiling limit prescribed thereby became effective, even though Chapter 4 was not extended by a notification under Section 1(3) of the Act. And since the subsequent legislation seeks to restrict the ceiling limit and to vest the surplus land in the government under Section 45 as amended, there is compulsory acquisition of land which may be valid only if the law provides for the payment to the landholders for extinction of his interest, the market value of that part of the surplus land which is within the ceiling limit under the Principal Act. This argument found favor with the High Court. In their view, the expression law in force must be construed only in the constitutional sense and not in the sense of its actual operativeness. And on that account, it must be held that there was a ceiling limit already provided by the Principal Act, as it was the law enforced within the meaning of that expression as used in the second proviso to Article 31A. They proceeded then to hold that Section 47 of the Act as amended provided for the payment of compensation at the rate which is less than the market value of the land falling within the ceiling limit as originally fixed under Act 16 of 1960. And the guarantee of the second proviso to Article 31A of the Constitution is on that account infringed. We are unable to accept this process of reasoning. The right to compensation which is not less than the market value under any law providing for the acquisition by the state of any land in an estate in a personal cultivation of a person is guaranteed by the second proviso only where the land is within the ceiling limit applicable to him under any law for the time being in force. A law cannot said, my lord, here is, my lord, where I harp on. A law cannot said to be in force unless it is brought into operation by legislative enactment or by the exercise of the authority by a delegate empowered to bring it into operation. The theory of a statute being in operation in a constitutional sense, though it is not in fact in operation, has in our judgment no validity. So, my lord, exactly, my lord, the authority which had the power to bring it into operation by giving an effect of amendment. My lord, then only it would be the law in force. My lord, today, admittedly, the deed of variation says the amendment shall take effect. These are the proposed amendments. So, my lord, to give it an operation, it has to be bring into operation. My lord, how an amendment would bring into an operation? By amending the provision. So, my lord, as on that date, the law in force is, my lord, I am entitled to 12 months salary. The gratuity calculation, whichever is higher. So, my lord, in this settled proposition of law, my lord, today Mamalari, my lord, being a state, cannot come up and take a defense that very well, my lord, now after your death, we have amended. We had an intention to amend, now we amend. My lord, this cannot be, my lord, the proposition of law. It only depends on, my lord, I would humbly submit, my lord, they would try, my lord, my other side would try, my lord, say this deed of operation is the amendment itself. That would be only their sword, my lord, against me. My lord, and the language, that's why I place the recital portion which says the amendment shall take effect. Or, my lord, the amendment shall be. My lord, these languages shall be means the amendment will be. My lord, even in civil procedure code, my lord, when an amendment is allowed by an honorable court, the court says you have to amend within certain time. If you do not amend, my lord, the law is settled, my lord, order 16 rule 18, you will be barred from subsequently amended. But, my lord, we are in a writ court, this bar doesn't apply. But definitely the principle in CPC is also recognized. Just by saying I want to amend doesn't mean there is an amendment.
Yes.
And if they, after filing of the writ petition, if they have given rectified in 2020 May 2022, after knowing, my lord, we are taking advantage of this clause, my lord, kindly seize their mala fide. When we write them, we are governed by 15.2.4. They suddenly, my lord, rectifies it. So, my lord, they were aware, my lord, this clause was there for the benefit of employees, and the trust, my lord, the gratuity fund trust rules is made for the benefit of the employees. My lord, if a beneficiary legislation is not amended, my lord, I say the benefit cannot be curtailed out by, my lord, and just by an intention to amend.
And after the amendment, how it stands today?
My lord,
According
after the
to them-
amendment, as per the gratuity rules, my lord, the initial was if
Ceiling of gratuity shall be increased by 25% whenever IDA increases by 50%.
yes, my lord, it's the, my lord,
15
gratuity
days
rule.
emolument, which is inclusive of the basic pay stagnation. All right, anything else?
My lord, this is on the point of law. My lord, factually, one more thing, my lord, my learned friend would take advantage of. Kindly takes up page 42 of the opposition. My lord has got that.
Yes.
My lord, kindly see signed and sealed. My lord, what was signed and sealed? A meeting marks this. My lord, this was only a meeting which was held.
Hmm.
So therefore, my lord, my contention is supported by a meeting. An amendment doesn't take effect.
Yes.
So this is, my lord, I rest my case on this.
Milord, first of all, Milord, my learned friend, Milord, I hope that he has taken my lord's attention, Milord, to page 7, page 6, Milord,
Page 6 of
of the opposition.
Yes.
Milord, one is Milord manual and the other is Milord the regulation. Now, Milord, the argument which my learned esteemed friend has advanced now, Milord, possibly, Milord, it is conspicuously absent from the pleading in the reply. Even then, Milord, I need to deal with this argument. Kindly seize, Milord, this regulation, the gratuity fund rules and regulation which took place with the approval of the Commissioner of Income Tax, an authority constituted under the Central Legislature, Milord, 16 July 2023 happened much before the date of the petitioner's husband, because 13. Hence, because her husband, Milord, passed away in the year 2021, subject to correction. Hence, the same was binding upon all the employees, including the said late husband of the petitioner, after his death upon his legal years. My learned friend would correct me, Milord, that the entire regulation has not been questioned in this. Yes. Now, Milord. And Milord, the amount that has been paid to him, her, Milord, kindly sees the aforesaid erroneous calculation was made on the basis of the unamended clause of such and such HR manual, which was subsequently rectified in May 2022 in line with the amendment in the company's gratuity fund rules and regulations effecting from 16 July 2023, which was duly approved by the Commissioner of Income Tax. However, before payment of the said gratuity amount to the petitioner, the error in the gratuity amount was rectified and communicated to the petitioner via email such and such, and the gratuity amount paid as per the provisions of the Payment of Gratuity Act and relevant gratuity rules of the company as amended. My lord, I have two submissions to make on this code. Yes. First of all, my lord, that this payment, these regulations, which was made effective from, my lord, 16 July 2023, whether when this particular paragraph, my lord, is, my lord, making a definite assertion with regard to the date of his effect. The question is, my lord, that whether it is prospective or retrospective, my lord, this question, my lord, today at the end of the day may be mere academic. Why I tell your lordship? Because my learned friend possibly has not addressed your lordship, my lord, that when a statute becomes clarificatory, it is always, my lord, retrospective. If it is in the manual, if it is clearly stated with in no uncertain terms, my lord, that these particular provisions are merely a guideline, then the question of its enforcement as a mandatory obligation under this statute, my lord, is possibly very naive and, my lord, irrelevant in at this very, very late hours, my lord. So, my lord, question he has not addressed the judgment which he has referred to 69(2) SCC 340. My lord, this, my lord, might be a very good one in respect of another rights, my lord, where he complains injury. Today, my lord, the clarification that has been made under the regulations, these regulations, my lord, have not yet been declared ultra vires, or that the authority has traveled beyond the power. If it is, there is an element of arbitrariness, my lord, he said, my lord, his choice of words, my lord, that we applied it as a short. My lord, the employer, my lord, is a role model employer. Now, my lord, we always exchange, my lord, bouquet of flower in the war field, not always arms. But the question is, my lord, that what he said today is possibly, my lord, misreading of the statute. Now, my lord, why I tell your lordships? What is the effect of deletion? Your lordship has asked him a question. Deletion means, my lord, it never existed in the history or the records of the parliament. Deletion means without any saving clause. When it is deleted, when income tax authority, my lord, has accepted this amount, when it is a clarificatory in nature, he has to show first that such amendment does not, my lord, bear any clarification. It is not a mere, my lord, question of, my lord, taking away a right of an employee, my lord, that has been accrued. Because when her husband was alive, this was made in 2013. Nobody had thrown challenge, my lord, with such alleged, my lord, infraction of right. So today, it is too late for the petitioner, my lord, to exercise his right, my lord, or power assertion of right. Kindly see, he has shown 24, my lord, page. All changes shall apply. Page 24 of your lordship's brief. Read petition. Read petition. My lord has got it.
24.
Of the read petition.
Yes.
This is a general offer of appointment, my lord, which specifically state this offer of appointment along with your acceptance thereto and rules and regulations applicable from time to time to your category of executives shall form the contract of employment between yourself and the company. My lord, 37 of the Contract Act 1872. Although, my lord, the government, my lord, parties are bound by their contract. They today, my lord, her husband, when he was alive, my lord, he was aware of such amendment and he, my lord, accepted the terms. Even if it is a beneficial legislation, my lord, the question is whether it is well within our power, my lord, to do so. Such power has not been questioned. Court cannot make out a third-party case. He is inviting the court to make out a third-party case. Number two, what is the averment of my learned friend's client that his client has been discriminated against? I cannot prove the negative things, my lord. I cannot show. If he can show that yes, X, Y, Z, these are the persons. After the amendment took place, they were blessed with such benefit, even though the amendment took place. Such records, my lord, he has not placed. So the issues that were never raised before the court, the dispute, I am not, my lord, entitled unless I get to know his mind. How can I deal with this? I put this question to myself. Now, my lord, the question he has said, Order 6, Rule 17. A procedural law, my lord, is not a substantive law. It merely a guidance, my lord, to the civil court's procedure. In this constitutional curial combat, my lord, possibly, my lord, his understanding of the CPC and the applicability of the principle in the instant case, my lord, possibly, my lord, has been painted with his own imagination and does not lend any meaningful assistance for the simple reason, my lord, there, the parliament, well within its jurisdiction, and the company law board and income tax authority all along has exercised his power in approving this. And more so, his silence with regard to the applicability of a clarificatory statute, which applies, my lord, retrospectively, this has not been questioned. At the cost of tiring repetition, my lord, I take my lord's kind attention. My lord, this manual, my lord, the manual, my lord, which I have annexed. 18. This is the, sorry, yes. Kindly cease.
18 is the rules and regulations.
Yes. Bamalori Gratuity Fund Company Rules, my lord, Rules and Regulation, 20th December.
Yes.
Now, my lord, these rules, my lord, known as such and such, interpretation in these rules, following person shall answer. These rules have been beneficiaries also. And my lord, this particular, the rules shall mean the rules herein contained and any amendment thereof for the time being in force. Then he says in force. Now, my lord, in 11, gratuity shall be payable to a beneficiary on the termination of such and such after she has rendered continuous service for more than. Kindly comes, my lord, to they are relying on Roman 3. Notwithstanding anything in subclause such and such,
Where
in
are
the
you reading?
page 22,
22. All right.
they are relying, possibly, if you have correctly understood his mind, my lord, that notwithstanding anything contained in subclause
Yes.
rule, in the case of a death of a beneficiary, the amount of gratuity shall be calculated under subclause 1 and subclause 2 during past years and such and such. This is doesn't rely. Now, my lord, kindly comes to, my lord, page 37. 37. Under clause 12 of the principal deed and the rules, 3, clause 3, page 38. I'm sorry, my lord. And the rules framed thereunder, the trustees have the power, with the consent in writing of the company and subject to approval of the Commissioner of Income Tax, having jurisdiction over the fund, to alter, modify, add to all the provisions of the principal deed and the rules made thereunder. In the events which have happened, the trustees at the present, the trustees of the fund. Now, my lord, the trustees as well as company have signified their consent to the said amendment as is testified there being parties hereto and executing these presents. And then, in exercise of the powers vested in the trustees and companies under clause 12 of the principal deed as amended as aforesaid, of all or over every other power thereto, by enabling trustee to hereby declare that the principal deed and the rules shall be amended in the manner to the extent hereinafter appearing that the said amendment shall take effect on 16th day of July 2013, which I have said. Now, and 40, কোথায় গেল? Page number তো নেই। না, দাঁড়া এক second. Yes. Now, my lord, rule 11C clause 8 and 11C Roman 3, the rules shall be deleted. This, according to him, my lord, he said, my lord, the signed and sealed delivered in where of the parties such and such or on behalf of the Mamalari company in terms of the authority delegated them by its board of directors such and such. Did he question, my lord, I put this question to this, such delegation was excessive? Did he question that this trust in the prayer, that it is not binding on her? She is not bound by the contract that was entered into between which I have shown. Did it throw, she has not thrown challenge to this deed. Such deletion there is an excessive delegation.
The primary contention raised by the petitioner is that this is a mere
Correct.
intention to amend, but not an actual amendment.
Right. He
Which
said, but we have
The
clarified.
actual amendment took place in 2022, which is
Is the question,
after
my lord,
the
that
death.
clearly mentioned the date 26, that is the 2013 we have mentioned. Question is, my lord, that assuming he is correct, but the deletion, effect of such deletion, he said it is not deleted if is the contention. Then he has to show it is surviving, it is subsisting. And in order to show, in order to prove his contention in this combat, my lord, he should have thrown challenge. If the power, source of power, my lord,
No, he doesn't question that.
he said,
That
my lord,
is
it is
not a question.
inconsequential. If he says, either he has to say it is inconsequential, or he
It
said,
comes into effect later on.
question
It is
my lord,
only this.
no, question is, my lord, this particular had given a reference, rule 11C and 11.2, 11C3, it says rule deleted. Now, my lord, this is,
When does it come effect from?
yes, 30th July 2013.
When did you intimate this? It's in 22? That is what is mentioned in your opposition?
The amendment in 2013.
6
The rules to the amendment in 2013 that incorporation.
effect. Yeah, please come to page 6
I
of
said
your.
it was incorporated later on in 2020 manual. Manual is a mere guideline. It is not mandatory. Whether manual will supersede, my lord, the company rules. He has not said so. In order to say so, my lord, first he has to show, my lord, manual, my lord, kindly says. 1.5, my lord, once again. The terms and condition for 1.415, the terms contained in the manual are for the guidance and may not cover all the eventualities. In case of any doubt, reference should be made to respective HR departments, the controlling examination.
What are you reading? Where did you
Page
read?
515 of my affidavit.
Yes.
Page 15 of my affidavit, clause 1.4.3.
1.4.3. Yes.
So this is, my lord, absolutely it says, it has not left any room for doubt. The terms contained in the manual are for guidance and may not cover. This was, my lord, intimated as per your lordship's query, my lord, 2022. But effect, my lord, given 2013.
2013.
My lord, this was, my lord, incorporated in the agreement which I have said, and clearly an income tax authority has approved this. And the terms and condition, the agreement which I have shown, your lordship, that the employee was aware, the contract says that we are aware of this. 24, page 24 of the writ petition.
If the manual is rectified in 2022,
It is incorporation in the manual in 2022.
when
but
the
fact-
employee died.
When the
So
employee,
employee was not supposed to know it.
but
That
employee is supposed to know as per clause 24 that such deletion made in 2013.
where
Sir-
from will the employee get to know?
Page 24 is said that this offer of appointment along with your acceptance that rules and regulations
No, that is
applicable.
all right.
Yes,
That is in general. Yes, I know everything. But where from does the employee get to know? He gets to know from the manual. And you update the manual in
That
2022.
ignorance of law is not an excuse. First of all, my lord, I could have understood that she has made out a case where XYZ, my lord, has been given the same, they have been given the same benefits,
And
which has been denied.
nobody has been given. You have filed an affidavit
Yes.
possibly. Dekhiye ekটু affidavit ta.
We have clarified, my lord, this was given to him.
My lord, I said I could not understand. On that very date, I could not understand this.
My lord,
Not the
Shumita
reply.
Basu,
Did you all file one document? একটা কাগজ
My lord, there is
রাখছে।
a small thing.
হ্যাঁ, একটা কাগজ দিয়েছিল।
এই কপিটা জজ সাহেবকে দিন তো। এই ক্লারিফিকেটরি তোকে দিয়েছিল যেটা
এটা
ক্লারিফাই
আছে আমার কাছে।
না না এটা না, এই চার্ট একটা দিয়েছে তোকে ক্লারিফাই
এর ভেতরেই লাগানো আছে।
ওটা ক্লারি
না এরকম আলাদা
Does
করে
it contain a back sheet?
দিস
Does it contain a back sheet?
Yes, my lord, there is
No.
a back sheet.
There is a back sheet. Is
There is
there
a
a
back
back sheet?
Ritesh Kumar Ganguly's back sheet.
Included in the application filed by.
আরে এইটার ওইটা কি?
Application. Wait.
তাহলে সেটাই বল, মোর ক্লারিফিকেশনটাও পাইনি
আচ্ছা। Yes.
এখন নে না তুই।
Yes, I've got it.
Yes, now my lord, this possibly will clear the air, my lord.
দেখি কি দিচ্ছে।
This is, my lord, the note, my lord.
Is it the same thing?
With better clarification, my lord.
Better clarification.
The accounts, my lord, kindly sees. First, I take name Shumita Bosu, wife of late Shunando Bosu. Gratuity amount 4,03,349. Date of payment 24 July 2020. Date of joining 87. Date of
Date of payment.
service 20 such and such. Period of service 33 years. Last drawn pay, my lord, basic I have given. Last drawn DA I have given. Stagnation and last drawn pay I have given. Gratuity amount, my lord. This was initially gratuity is equal to
24,012.
gratuity LX plus HX.
ও এটা ওটা পড়ছি। এটা কপি দাও।
L into H into last drawn H is, my lord.
Period of service.
Yes.
এটা কপিটা নেই গো, এটা আমি ধরতে পারছি।
এটা না না ও ধরতে পারছে না।
15/26.
এটা কত L H টা?
L into H.
L into H into A into 15/26. The calculation made, my lord, ultimately, my lord, gratuity amount 4,03,000 something. It comes to, my lord, 4,57,151. Similar principle, the similar method of calculation, my lord, applied to him also. Now he has to controvert, my lord. Then, my lord, kindly suit Tathagani. Thangamani is 8,70,000.
We are not going into each and every one, but then the chart that you have placed is
So
the
the same
period.
principle, if I find at the end of the day that there is an error on my part, then I have to compensate her. I have to say this is the calculation. Now, my lord, in order to show, then all other arguments go, because I am bound by my own admission. If I rely this chart before your lordship, my lord, I am, my lord, bound by this chart. Then, my lord, he has to show that where is the method, my lord, wrong method, my lord, that is computed. Is there any error? Such error must be rectified. And, my lord, question is, if error, my lord, committed by an authority also, my lord, I am required to rectify it, but a mistake of law, not if my lord, if the law does not permit me to do something, then such even by mistake, my lord, I have conferred a certain benefit.
All right, I've followed.
May I give a very short reply?
Yes.
My lord, whatever has fallen from a learned senior friend is as if, my lord, a dead person knows something has come into effect, and my lord, the dead person, my lord, is bound by his
Was alive.
contract.
Sorry.
And dead person, my lord, is aware of the, my lord, contractual terms, and my lord, he will raise an objection before the authority. Look, you have not done this, not done that. Now, my lord, this is his primary contention.
No, thing is, see, without going into all these things,
Yes.
you say
Yes.
that the amendment, even though it was made, was not given effect.
Given effect.
This is your.
Or not brought into operation. It was a
If that had not been brought into operation, then this chart, what will be your answer?
My answer to this. My answer to this. My lord, suppose an authority, my lord, being an authority, my lord, knowingly, unknowingly, my lord, is doing something which is wrong as per law. nobody raises an objection. Does it curtail my right to raise an objection?
Very well. This is the only reply. I get it. Hearing concluded, CAV.
My lord, sorry, my lord. I'm really
Conclude.
Because you've concluded your argument, you do
Yes,
not have
yes.
anything else to say.
No. Only liberty, my lord. May I have the liberty to file a written notes of short written 2 pages tomorrow, day after tomorrow?
Will it be required?
Not required. One question of law, my lord, that. আবার কি তুমি তো সব-
ঝামেলা চাইছি।
আচ্ছা,
What is there to add up?
As your lordship. Deeply obliged.
much obliged.
এই পাখাটা একটু চালিয়ে দিন তো এটা।
My lord, before your lordship calls the appellate side matter, my lord, may I seek an indulgence on it? Before your lordship calls the appellate side matter, my lord, pursuant to your lordship's order, I have deposited around 3 crore 50 lakhs. Now, my lord, the problem is
Where?
with the WBFC, the financial corporation, my lord.
Which matter?
In an appellate side matter, my lord,
Yes.
there was an order passed in a writ petition where I am not a party.
Yes.
But I have deposited because there was a chance of, there was an auction bid, I have deposited the money. Now, my lord, since the writ petition is pending, the sales certificate is not being issued in my favor.
Yes. So
I am suffering, my lord. I have deposited the money. I want to purchase the land. They are not executing the deed in my favor.
yeah, what can be done?
My lord, kindly, my lord, allows me to file an application for intervening so that it can be taken up
File it in
tomorrow.
the department. Nobody is standing in the way.
My lord, only thing is that I have filed two. There is one addition of party because I was not made a party.
File it in the department. I'm
May I
not
come back tomorrow for the
Not
application?
at all. File it in the department. Call the list, please.
Not extreme predicament, not I mentioned. I seek your lordship's leave to mention an original side matter.
Yes.
The officer is not just being called. But there is a direction to close my shop not from tomorrow.
Item 1.
No, it's on the original side, but I'm seeking.
Original side.
Tried to get it affirmed, so I could not mention in the morning.
Yes.
But the commissioner was not available by 10:40, so not I could not
Yes.
get it affirmed.
Uh-huh.
But on 19th, there is an 18th, there is an order issued that by 20th I should have to close down my shop.
Who has issued the order?
It's issued by the state government through the fire department.
Fire department. You do not have a fire license.
So that's not their contention.
Obviously. Now, from tomorrow it will be shut. Let it remain shut. If you do not have a fire license,
I
the
do
court
have,
cannot
the-
permit.
No, I do have. Not the question is not.
File it in the department. It will appear in the list in due course. If 2 days the shop is remain closed, nothing is going to happen.
It is an ongoing business. Not with
Let
50
it remain. Business for what?
Garment shop. Garment shop.
Garment. It won't perish. It will remain over there.
no.
File it in the
And
department.
most persons don't buy to the go to the shops for purchasing nowadays.
Then what is the
But
use?
still-
Opening it, non-opening it,
But
you
still
go
not
and
we have got
sell it
50
online.
employees. Still not 50 employees.
Even then, nothing doing. File it in the department.
But there was an
Yes.
interim order passed by the court not once, and their report is relied upon without serving a copy. We write
File
to
it
the,
in the department.
we
No,
write to
sorry.
the state for a copy of the report that is also not served on us.
File it in the department. Yes.
No, I was assisting Mr. Mujumdar in a matter I could not mention in the morning. My 3.5 crores is lying with the authorities. Sales is not being, the certificate is not being issued in my favor. I am
It was
filing an
mentioned
application.
just now, possibly.
Filing an
not.
application made appear tomorrow.
No. File it in the department. Yes, call the list. For release. Why for release? Not in this determination? জানা বাবু, ওইদিকে তাকিয়ে থাকলে হবে না। অন্য কোনো বেঞ্চে যাবে? না মানে সত্যি
Yes. Evidence service. Evidence service. Lord, this
Yes.
is my lord, they kindly appreciate to that. I'm drawing lordship's attention annexer P1. This is my lord, the assignment of a service. Now, page 25. On the page 25.
জানাবো এদিকে পাখাটা চালান এই শৈলেশ পাখাটা চালাতে বলুন তো Yes.
Page 25. Lord, my client was assignment of the service, Lord, in the first column, my lord. That is, my lord, on 2nd December 2024 to 21st January 2027 at Germany. Got your lordships?
Yes.
Page 25. For the particular purpose.
Page 25.
Yes, ma'am.
Your lordship,
What you are reading?
Right hand side,
The-
third paragraph.
Right hand side, third paragraph.
No. This is the first paragraph in the left side.
Left side, third
Left side,
paragraph.
third paragraph.
Yes.
Well, this is, my lord, the last portion. The commencement date of this secondment will be on 2nd December 2024 to 21st January 2027.
Yes.
Well, for the purpose, well, the passport authority, I made the application for the passport authority.
No, you have been provided service here in India.
No, this is for Germany. Engagement. This appointment here is for assignment to the Germany. I have to.
Where is that?
That is that's just first paragraph. This portion just Germany.
Where?
This is the I am just in the same site.
Same side?
Yes, ma'am. Solution such and such during which time.
Oh, you'll be working in Germany. Yes.
This
Yes.
is for the purpose of pair for passport authority. Now the drawing lordship's attention to page 20, 40, 90, 43. 43. Annexer 4.
Yes.
This is the passport authority has, my lord, the issued the notice of so called.
Your
Lord, in the
lordship,
second
our
paragraph.
pages are of this. We are not able to even.
মাস্টার নিয়ে দেখে নিন একটু
আমরা instructions section এ দেখাবো না।
ঠিক আছে এটা দেখে নিন আমি এটা থেকে অ্যাড্রেস করছি এটা দেখে নিন
A criminal proceeding is pending in a court against you.
Yes. This
Right.
is, my lord, the proceeding under section 498A.
498A.
498. That has been, my lord, I all the granted bail. I granted bail, regular bail.
Yes.
And thereafter the order by Justice Bakchi, this in already, my lord, state proceeding says page 40.
Stay of operation of the proceeding.
Page 40.
Before for a period of 6 weeks after puja vacation or until further order, whichever is earlier.
And thereafter the time has been extended.
It has been extended from time to time. Yes.
Well, this has been, my lord, the so-called has been issued. By virtue of that, I could not attend the service. My responsible submission, the section, it has been mentioned, section 10, subsection 3E. This I have gone through this, my lord. So, my lord, this has been something else. If it is the warrant issued has been.
Did you obtain a certificate from the learned court?
I made, my lord,
No objection
I
certificate.
made the application before the authority. I beg to apology, file the supplementary affidavit to that extent. During pending of this read application, I made the application before the magistrate passed an order. A copy has been served. Lordships are drawing lordships attention by way of supplementary affidavit in the ordering portion. এই কোশ্চেনটা কত? Order.
Page 5.
The page. Order dated, my lord, 27 January 2023, 25.
Page?
In the first, just impugn order first.
Page 5.
Page নিতেন তো বড়।
What is it? I want to put it in.
Okay, sir. Thereafter, I made the application before the concerned.
No, what does it today is fixed for confirmation of bail. CS has been submitted, interim bail is confirmed. Intends to renew his passport, for which he is directed to approach before the appropriate authority. Where is the no objection from the
This has
learned
not been
court?
issued.
Obtain that no
No,
objection.
It has been not issued during.
Who has not issued?
Highly appreciate to that. My lord, by virtue of that, the accusations and supply a copy of the petitioner dated at the session is disposed of. Directed to appear before the appropriate authority by the order.
Approach the appropriate authority.
I made the application.
This
With
will
that-
not do. You obtain a no objection from the learned court and you get it done.
My lord, the things for a moment, I tried my level best
What?
before the magistrate. Before
Then his criminal revision proceeding is pending.
then also observation, such observation should be given.
What
Otherwise,
observation?
My lord, before the approach before the magistrate to have the no objection in terms of the provision. Otherwise, my lord, this seems, my lord, read application is pending before lordships.
Where is
I
your
tried my
petition?
level best
Where is your application before the
with the authority.
not the authority, before the magistrate?
Page 6. Page 7.
Page 7.
Yes.
Did you pray for issuance of a no objection certificate?
Necessary order.
Seeks permission of the learned court to visit abroad and thereby and may be directed to issue renewal passport. Please to allow this petition. This petition should have been properly drafted in such a manner so as to indicate, show the
Yes,
GSR is there.
570.
Please.
GSR 570.
That has been done, my lord, and it could be done, my lord.
Sir,
that
you
is-
just pointed out, well,
I've
GSR
seen,
570
I've
should be
seen.
pointed out to the learned court.
I've seen.
And the
This-
court should act
this
on the basis of the
application
GSR
has
570.
Otherwise, my lord, the service will be affected. Innocent of the- Innocent of the-
Please come.
No, it's section two.
Section, sir, there is a circular, circular.
The petitioner
Done.
has been directed to show cause as to why his passport should not be impounded / revoked under section 10 within bracket 3 within bracket small e of the Passports Act, 1967, as adverse police report has been received against him with the observation that criminal proceeding is pending in a court in India against his name. Stop. Learned advocate for the petitioner submits that the proceeding is under section 498A. Stop. The Acha 498A/406/34 IPC. Pending before the learned Chief Judicial Magistrate Barasat, North 24 Parganas. Stop. The said proceeding is stayed in terms of the order passed by this court in CRR number 3405 of 2024. Stop. Acha, order date ta din to 26th of September 2024. CRR. Next. The petitioner has relied upon an appointment letter and submits that he has been offered appointment in Germany and he intends to travel abroad for service purpose. Stop paragraph. The petitioner has made an application before the learned trial court where the matter is pending, and vide order dated 27th January 2025, passed in GR number 2149/2024. The petitioner has been directed to approach the appropriate authority. Stop. Next. Prayer has been made by the learned advocate for the petitioner to direct the passport authority to permit him to travel abroad and not to take any steps for impounding his passport. Paragraph. Learned counsel representing the passport authority relies upon the notification of the Ministry of External Affairs, being GSR number 570 within bracket caps E, dated 25th August 1993, which mentions that the passport may be issued in favor of a citizen of India against whom criminal proceeding is pending if the citizen shall give an undertaking in writing to the passport authority that he shall, if required by the court concerned, appear before it at any time during the continuance in force of the passport so issued, and the passport may be issued in favor of such citizen for the period which the court desires. Stop. If no period is mentioned, then the passport shall be issued for a period of 1 year. And if the permission for travel abroad is more than a year and the period is not specifically mentioned in the order of the court, then the passport shall be issued for the period of travel abroad specified in the order. Stop. Next.
The one
It will be
one international. My client, my lord, the holding the passport for last 10 years.
so it is valid
Other assignment.
till
But today
valid till
valid time to time extended by
now. Right now, is it valid or not?
Yes, ma'am. If I be permitted.
There is your learned advocate is there. Please speak to him.
Passport issue হয়ে গেছে renewal এর, তারপরে
last date for
এই আগস্ট মাসে হচ্ছে 24
Lord, that is valid date, within valid date. Just.
What is the last date of validity of your passport?
It's
August 34.
August 2034 is the last date.
The passport is valid till the month of August 2034.
Renewal হয়েছে, after the renewal.
Till the month of August 2034. Stop. Paragraph. As the passport authority will be bound by the notification GSR 570 within bracket E, it will be open for the petitioner to take steps in terms of the said notification. Stop. The writ petition stands disposed of. get a copy of this notification and then take steps. Supplementary affidavit filed
The
in court
only-
is taken on
only
record.
lands, my-
Affidavit of service
My
is
lord, the
taken on
only
record.
hindrance, my lord. Since, my lord, the learned magistrate opined that advice, my lord, since the order has been stayed, proceeding has been stayed, they are bound in terms of either by the passed by the High Court or they cannot be passed the order.
That
is
is
it, that
in
is
respect of that petitioner,
that
not in respect of other accused. And the order has not been extended from time to time.
It has not been, but this is what he said.
No, my lord, kindly see, my lord, this revisional application, my lord.
This is the same proceeding.
It's not disposed of, but then I don't know, it was submitted that it has been extended.
I do not know, my lord.
Extended, time to time extended.
I have not.
Wanted to extend it.
That is, my lord,
That is that.
This is what he said and this is what has been
I
recorded. I don't know. I have recorded your submission.
Extended time to time.
I mean, this is in respect of one Shashwati Das.
Not in respect of the petition.
This is also the same proceeding.
Proceeding.
Yes.
Proceeding in respect of that Shashwati Das.
Yes. Call the next matter.
Developed.
But I'm appearing for the petitioner, my lord. I'm led by Mr. Mitra, who's appearing virtually, my lord.
My lord, I'm sorry. My lord, kindly allow me to appear virtually.
Yes,
My
yes,
lord, your
certainly.
ladyship will take the last day's order, my lord, on 13th of February.
Last is.
I have this order.
That's the last day.
Take it back. Yes.
Yes, my lord, they have not given us the preliminary inquiry report thus far.
Where is the preliminary inquiry report?
Preliminary inquiry report cannot be given because of that has not been finalized. Well, this is if you lordship ask another question, last occasion you lordship recorded the order. That they have submitted but no notice has been given prior to preliminary inquiry. This notice has been given with notices before the lordship.
Copy them.
Are you all intending to stop plying of the other ships of the petitioner?
No, in 3% died.
Yes, that I know. But then there are other ships. One which has drowned, capsized is gone. There are other ships of the petitioner where the petitioners have a certificate in their favor. Right? Are you all intending to take steps against the other ships of the petitioners?
We are taking.
What is your instruction?
This is for given notice to the petitioner
to attend
for preliminary inquiry.
Then what happened? Did the inquiry take place?
Inquiry took place. Inquiry took place on 7th of October 2024.
So from October till February, you couldn't finalize.
That has been sent to DGS.
Wherever you send it, does it take such a long time?
So, that is my instruction that that has been not finalized.
So what does this mean? That you are not intending to take?
Before that one, Soko's notice, last Soko's notice.
No, that I followed.
Notice a copy देंगे जब अपने handover कर ले. Copy नहीं.
Show me that this notice was served upon the petitioner. Maybe you have it in your books, but where is the proof of service?
Proof of service is mail has
the
been
mail.
They have given attendance. If you lordships kindly have a look on 7th of October 2024.
Did they attend? Anybody? All day.
First, it was fixed on 30th September. They have prayed for adjournment. Thereafter, it is adjourned to 7th of October.
See what is mentioned.
Let them hand over a copy of the whatever
Yes,
documents they have. I don't have a copy. I don't know what they're relying on.
They are not relying on anything as such. It is only the statement. Arup Roy, who is this person? The deck cadet. And designation is something which says that the captain of the ship was very old. He is more than 70 and he has knee problem. He cannot walk normally, and had he been active and taken decision early, then the ship could have been
That is-
saved and life could have been
That
saved.
is, my lord, a separate issue altogether where three crew members have already passed away.
Yes,
That's a
yes. It
separate
is
issue.
only with
I do
regard
not
to
know,
that.
my lord, what, yes, my lord, that is, I understand.
And-
So far as the show cause notice is concerned, now they say that,
And
my lord, I mean, led by Mr. Mitra, I'm sorry, my lord. I'm sorry.
Yes.
with your ladyship's leave, I can just take the liberty to remind your ladyship of one
Please come.
fact, that the SCNs is conclusively established.
Acha, the learned advocate representing the respondents submits that the preliminary inquiry report has been forwarded to
respondent number 2 from respondent number 3. Respondent number 3
the respondent number 2 from the respondent number 3. And the same is yet to be finalized. Finalized or approved? What do you say? Approved. Approved. Stop. Very well. Now the respondents are directed to file
for technical review. For technical review. That has been sent for review.
Oh, for approval na, for technical review. Approval bolan to. Same has been forwarded for technical review. The same from 3 to 2 for technical review. Achha. The respondents are directed to file their affidavit in opposition. How soon can you do it? 4 weeks. Reply, if any, within a fortnight thereafter. Stop. The interim order that is subsisting is extended till 30th of April 2025 or until further order, whichever is earlier. Stop. Lists the matter immediately on completion of the aforesaid time period.
Lordship is extending the interim order, my lord. My lord, may I just indicate one thing, if your lordship kindly takes page 56 of my writ petition. They say that it has been conclusively established that IIT Shipping Private Limited failed to exercise.
Yes.
Now they say that they have sent it to the DG Shipping for verification.
Yes, call the next one.
Contradictory manner statements, my lord.
For technical review.
The lordship is extending the interim order to 30th April.
Yes.
I'm grateful. I'm grateful.
My lord, I appear for the petitioner. The matter relates to exotic birds.
Yes.
Now, coincidentally, this is the first petitioner of whose petition your ladyship had the occasion to deal with in bird matters. Your ladyship had disposed of this petition. The grievance with which the petitioner first came before your ladyship was that his applications for registrations, some applications have been
Rejected
informed
without
that-
giving any reasons.
Yes.
Now the reason has been mentioned.
Yes. The second fold allegation was that the appellate authority under Rule
Has
10
not been
has not-
disclosed.
So there were two folds directions also. The first fold has been complied with.
Now the appellate authority has not been intimated. Who are you for?
My lord, I am for the Union of India, my lord.
Yes.
Just yesterday evening, I have received the brief. My lord, if your lordship kindly give days accommodation so that I can take instruction from the department.
Just take instruction as to who is the appellate authority. I'll forward them there.
My lord, if your lordship tomorrow, my lord, if your lordship one.
Yes.
Yes, yes. Only this.
If your lordship kindly take up the
Name of the authority.
Yes, my lord. I just want to contact.
Yes.
Yes.
Yes. That was the reason why the order was passed at the last
my lord.
occasion.
I have gone through the order. If your lordship kindly take up the matter tomorrow, my lord.
Please come.
Your ladyship, we are enjoying an interim protection which expires today.
2 weeks after the date of communication of the order was the interim order.
Yes.
And one thing, my lord.
Expiring today.
Yeah, it was communicated on 5th, so today is the 15th date.
And one thing, my lord, may I
yes,
submit
19th.
60-day time has been granted for the appeal, my lord.
Yes.
Has
Did
been
you give-
granted.
Yes,
So
ma'am.
you are protected by that order.
Yes, my lord.
Very well.
If I may voice my concern with regard to this, the rules demanded that registration be done within 30 days of receipt.
Acha,
On the third day, I had
petitioner is
been
aggrieved by the reasoned order dated 5th of February 2025, passed by the Chief Wildlife Warden and Management Authority, West Bengal. Stop. The appellate authority is the central government. Stop. Learned advocate for this Union of India shall intimate the actual person before whom the appeal is required to be filed. Stop. List the matter day after tomorrow.
Day after tomorrow, the Lordship.
Friday. I give you one more day.
Yes, my lord. In the meantime, I will take instruction.
My learned friend should allow us to go and see.
Yes, my
Sure,
lord.
go. Who is stopping you? Who is stopping you?
State has the
Exhaust
authority also. State has the authority also to go and inspect.
Yes. No, he is not the state. Yes.
Personal level, anytime, anytime.
Grateful, my lord.
Your ladyship has been
Day after tomorrow.
Day after tomorrow.
Only concern is that previously I have been taken and put into custody. When I had time for 30 days to register, on the third day they come, arrest me, seize my birds, put me to jail. This I apprehend may
They
also
wanted
happen.
to take your birds possibly.
They have taken, 2 are missing.
2 are missing.
Yes, yes. I will not rake up those issues, but I fear the same might be done within these days.
No, 2 days. Day
Only, my
after
lord,
tomorrow.
my
In
lord,
case
there is
anything
a-
happens,
I'll-
I'll put him in
Yes,
jail.
my lord.
Yes, yes.
Grateful,
Then
my lord.
this is assurance
Grateful,
enough.
my lord.
May the affidavit of service be kept on
Yes,
record. Your
service taken on record.
Grateful, my
Sir, apni shopkeep
I am for the petition, my lord. I kindly have a look at Lordship's order dated 14th of January 2025.
MMR.
Amen.
Yes. Selection of members using his
Now, my lord,
status as a member of the
the
committee.
respondent number 7 was at liberty to use affidavit, my lord, report in the form of affidavit.
Hmm.
Last night I got a soft copy. Today just they have handed over this stuff. But kindly takes up page 6 of that report. Report. Affidavit. The affidavit. Clause VIII. That the respondent number 7 passed alim examination from the West Bengal Board of Madrasa Education in the year 2003. Thereafter, and I have acquired my higher secondary education from the Board of Secondary Education in the year 2010. Thereafter, completed graduation from Stern Institute for Integrated Learning in Management University from Sikkim, wide enrollment number so-and-so of 2013. That subsequently I have secured Mufti certificate from the West Bengal Ulema Board and Furfura Sharif in the year 2022-2023. Your deponent craves leave to produce all the relevant educational certificates at the time of hearing if required. But I fail to understand why he is so shy to annex those documents. And one thing I learned from here, that from the West Bengal Board of Secondary Education, a person can pursue higher secondary examination. 2003,
so far,
from board 2003, after 7 years, from secondary board has secondary. No document has been here, my lord. But I have 3 years doubt about this qualification. And after 2010, 2013 from Sikkim. But that university, that's a disputed university. I have gone through the document. But let my learned friend supply the
Sikkim, which
testimony.
university?
EIILMU, which is under dispute.
let my learned friend complete, then Mala.
Yes, yes.
I'm waiting, madam.
So at,
And what is the, is there any minimum educational qualification
no.
required?
or a person who has been engaged to advise in case of selection of MMR Kaji, and he is
Has
the
this educational
the
qualification?
only Muslim in that particular committee. So we must presume that he must have the knowledge of Mohammedan law as well as Islamic culture. And this is the qualification. Our claim was that except Fazil, he didn't have anything.
I pay for the
State.
state.
Yes.
Lordship, before I give my report, handover, I have prepared a report. Lordship kindly refers to the conduct of the petitioner.
All right.
Lordship refers to, if your Lordship, if your ladyship kindly takes up the writ petition, page 36. That's his representation.
Yes.
Your ladyship, if you kindly refers to the second paragraph, it has come to my attention that Mr. Sheikh Shahid Akbar is misusing his official capacity in a manner that is both unethical and illegal. Specifically, Mr. Akbar has been using social media platforms, particularly Facebook, and has published his name and associate titles in newspapers with the intent to engage in activities that are not only inappropriate but also illegal. These actions include, but are not limited to, the abuse of position of Mr. Akbar has been leveraging his official title and position to gain undue influence and trust on social media through misleading people. Ladyship, there is no specific allegation. This is the final representation which I received regarding how he has been misusing his social media account. He has been not soliciting for any money or any favor. There has to be some kind of allegation. For the first time in the writ petition also, there was no such allegation. Averments were there. For the first time, the averments has been made through the supplementary affidavit. Your ladyship kindly takes up the supplementary affidavit.
Yes.
Page 5, paragraph 5. Your petitioner states that the private respondent has no qualification to conduct or as post of the board members to be appointed as a Muslim registrar in the area of various districts in the West Bengal. The private respondent is Fazil failed. That means not even qualified. The post of 10+2. How can someone who has no qualification conduct a selection procedure for some more qualified than him? Your ladyship, this is the first time the averment has been made that regarding the qualification. In the writ petition, there was no iota of allegation was made.
What is his
Now my
educational
report.
qualification?
Like, please the report.
Do you have the supporting documents of the educational qualification?
Educational qualification, I have the supporting documents and the rules also, your ladyship.
Yes.
The rules are also with. I'll place the rules later on. It is pertinent to mention here, your ladyship kindly refers to the last paragraph. It is pertinent to mention here that in the madrasa education system, alim is equivalent to madhyamik examination. Fazil is equivalent to higher secondary examination.
I want to see the supporting documents.
Supporting documents.
Because your submission and the submission of the private respondent are completely diverse.
Your ladyship, that he has been appointed by Minorities Commission. As
No,
per the-
Minorities Commission is all right, but the educational qualification. Your document over here says that the private respondent completed Kamil from the Alia University.
Commission has given, your ladyship kindly refers to R3, page number 3.
Shahid Akbar.
Premier, he has committed. Premier educational.
From Alia University.
From Alia. He has come.
Where is the document? Where is the document? The private respondent doesn't say that he has qualified from Alia. He says from Sikkim. And now you say Alia? Huh?
Everything is Alia.
Shahid Akbar.
Let me see your qualifications, please. And
Shahid Akbar from Alia University. Your ladyship, this is the report I have. From Alia he has. Shahid Akbar is the private respondent. From Alia he has. That is my report.
Shahid has filed an affidavit. Did you get a copy?
Complaint is Shahid.
Did you get a copy of Shahid Akbar?
Shahid Akbar.
Right. See what he has stated about his educational qualification at page 6. It was read out just now.
Would your lordship allow me to make submissions, my lord?
I'll see the document. 21st November 87 is your date of birth. Alim in 2003. West Bengal Board of Madrasa Education. Anime examination 2003. Certificate of this ulama board, right? This education, what does this mean?
My lord, the
Certificate of IFTA?
my lord, this is a course which has been provided by the
2023
Lordship.
Board of Secondary Education, Madhya Bharat, Gwalior.
Lordship.
From Gwalior, you obtain your educational qualification. Which MP? Main examination, admit card, intermediate, 10+2.
That equivalent to the 12th class.
Here it has been recorded from the secondary education West Bengal. Higher secondary education from the Board of Secondary Education.
But then the rest is blank. Board of Secondary Education, not from West Bengal, but from Madhya Bharat, Gwalior MP. In 2010.
He traveled throughout the India Mala to obtain.
English, Bengali, History, Economics and Political Science. Examination Center, such and such. Board of Secondary Education. The graduation examination certificate that you have placed over here, was it a regular course? And the higher secondary examination 10+2 intermediate that you placed, was this regular? Did you go over there?
Lord, I'm not sure. According to me, perhaps my lord, it is a private. He has been completed, my lord.
Yes, completed. All right.
My lord, before take trouble to the educational
Advance.
qualifications with regard to the petitioner, respondent 7 is concerned. My lord, your lordship, take note of this documentary evidence, and your lordship kindly allow me just 1 minute so that your lordship can take trouble to the original petition part is concerned. My lord, should I start, lordship?
Thing is,
No, I'm coming. Your lordship, keep all the documents, your lordship kindly.
What the concern of the petitioner is that somebody has been appointed as the as advisor.
Advisor.
Kindly allow me just 1 minute. Just kindly allow me, then your lordship can. My lord, who is the writ petitioner? First, I'm asking this question to myself first. If your lordship take trouble to the 4 corner of the original application, who is he? My lord, in the foregoing paragraph of the writ petitioner, from paragraph number 1, 2, 3, 4, up to your lordship state, we come to the paragraph 6. He has been appointed as a Muslim marriage register in respect of Hooghly district under Chinchura, Bolagod Part B, Polba in the year of such and such in 2024. He has been already appointed a marriage register in respect of Polba area. Now, he has challenged an action of the government that for appointment of a committee who provide suggestion and recommendations to the government for being appointed a Muslim marriage register in respect of the concerned district is concerned. Now, in terms of the policy of the government, in respect of only Hooghly district's committee has been initiated.
I'll hear you later on. Please come 1 minute. Learned advocate representing the state respondents has forwarded a report, has forwarded instruction from the OSD and ex officio joint secretary, Law Department, signed on 22nd of January 2025, disclosing that the private respondent obtained Kamil degree from the Alia University.
ILL. Alia degree.
Stop. Learned advocate representing the private respondent has filed an affidavit before this court where he does not mention about obtaining the Kamil degree from the Alia University. On the contrary, the private respondent avers that he passed Alim examination from the West Bengal Board of Madrasa Education in the year 2003 and acquired higher secondary education from the Board of Secondary Education in the year 2010. Stop. In support of the higher secondary qualification acquired by him, the learned advocate has produced the copy of the certificate issued by the Board of Secondary Education, Madhya Bharat Gwalior, within bracket MP, intermediate, within bracket class 12th, bracket close, examination year 2010. Stop. The private respondent has also averred that he completed graduation from Eastern Institute for Integrated Learning in Management University from Sikkim and has also annexed the certificate and the statement of marks.
Oh, he didn't annex, my lord. He has handed over it.
Acha, handed over, not annexed, handed over. ঠিক আছে? Statement of marks. The qualification relying on which the private respondent was offered the appointment does not match with the qualification disclosed by the private respondent in his affidavit. Stop. Let photocopy of these documents handed over by the learned advocate for the private respondent in court today be made over to the learned advocate representing the state respondents for taking further instruction. Stop.
Your ladyship, sorry for troubling your ladyship. This post has been nominated by West Bengal Minorities Commission. So they has to be made party because nomination has been done by the state has no role. Commission has appointed, made the nomination. So the letter also says so. So until unless Minorities Commission is made a party, I am not in a position to ascertain because they will be having all the documents. Your ladyship.
You are certainly in a position to ascertain, but then it is for benefit of everybody. I'll direct him to implead the commission also.
Much obliged.
You, in the meantime, will inquire from this. Acha. লিখে নিন তো। কি বললাম last টা? To hand over. Yes. Instruction from the West Bengal Minorities Commission. Stop. Leave is granted to the advocate on record of the petitioner to implead the West Bengal Minorities Commission as party respondent in the instant writ petition and serve copy of the writ petition upon the added respondent. Stop. The matter is directed to appear in the list on 12th of March 2025.
And may I get a copy of the certificates supplied by the my learned?
First copy will be made and handed over to the learned advocate for the state. Thereafter,
yes, ma'am.
It will be seen.
Good.
এগুলোর ফটোকপি করতে হবে। Yes.
Good. Good.
Lordship.
Yes. Were you mentioning something?
Look,
I'm changing the placement.
Absolutely.
From petitioner now. Respondent.
একটা কপি দিতে হবে ওনাদেরকে।
I appear for the petitioner.
Yes.
In the present petition, I have challenged a tender invited by the Mr. Jahan's client.
Oh, the Uttar Pradesh one.
Yes, Lordship, kindly take up the report filed on behalf of the respondent number 325. Lordship, they have stated in their report at page 2, paragraph 2A,
Page 2, paragraph 2A, yes.
that the UP Small Industries Corporation Limited has its own rules and regulation which provides that only after enlistment with this organization, the contractors would be entitled to take part in any tender process conducted by UPSIC if they are otherwise eligible. Lordship, these rules and regulations, they have not been annexed with the report. Lordship, I have annexed with my reply. Exception, reply to exception. Led by Mr. Bose. Lordship, kindly come to page 32 of the exception to my to the report filed by the respondent number 3. Page 30, it is the rules for enlistment of contractors in UPSIC Limited. That is the respondent number 3. Lordship, kindly come to the next page, page 32, 3. The second paragraph from the top. Contractor enlisted under any class shall be permitted to tender in UPSIC.
30, page 30.
33.
33, yes. Contractors enlisted.
Yes. Under any class shall be permitted to tender in UPSIC Limited anywhere in Uttar Pradesh. Lordship, this particular tender is connected with West Bengal and Sikkim region. So these barrier which they have put, that has no binding on this particular tender, because this particular clause is valid when the tender is invited for any contract within Uttar Pradesh, not beyond that. And Lordship, the principal tender invited by the Employees State Insurance Corporation.
English is a very strange language and it's not our mother language. So there is a different interpretation to what you have said.
Yes.
It can be. It is not necessarily restricted in Uttar Pradesh only.
Yes, anywhere in Uttar Pradesh.
Yes. So anybody from Uttar Pradesh can.
The tender, Lordship, I am led by Mr. Bose.
Contractor enlisted under any class shall be permitted. First is contractor, then will not permitted to tender in anywhere in Uttar Pradesh for the category of the works they are enlisted.
Yes.
So enlistment, kindly says contractor enlisted under any class, every class shall be permitted to tender. So submission of tender in UPSC Limited.
Anywhere in Uttar Pradesh. So it is not necessarily in a particular place. Anywhere the tender takes
within
place,
the territory, I said.
can be done.
I said within the territory. Question is, Millard, he is an agent deployed by Millard, the government. Now the agreement which my learned friend was showing, page 16. This is of the
See,
exception.
the mother tender, possibly the Uttar Pradesh was successful.
Yes.
In the mother tender. He is the contractor. Suppose he would not have gone out for a subcontract. Then you would have been nowhere.
Question is, Millard, such localization must be relatable with the object or nexus with the object sought to be achieved. Now, Millard kindly says, otherwise, Millard, I will not invite the court for a roving inquiry. I am only saying the element or proof of arbitrariness. Today, Millard, the memorandum, he is bound by the contract. What is the contract, Millard? Page 16 of my reply. Page, no. 21. Of page 21
of my
exception.
Only
which clause?
Page 9. PSU agency, page 21 of the clause 19, page 21 clause 19. PSU agencies shall have to engage only licensed certified electricians and operators are deployed. Preferably all other skilled workers deployed should also be licensed and certified. Other certificate of essential qualification should be verified before deployment of such and such. All deployed manpower engaged by the agencies for smooth functioning must mark the attendance. These are the only conditions. So condition will not enumerated shall be certified electrician operator. He must show, because this is a contract between ESI and this my learned friend's client. So the contract says that what he will not do. He will not go beyond the scope of this contract. Clause 19 binds himself. He be parties. Kindly see what is the condition. Shall have to engage only licensed and certified electrician operators. We are the license. Does it say, Milord, I put this question, the license must be given by the state, particularly Uttar Pradesh, in order to, Milord, execute a work under a contract in West Bengal and Sikkim? I put this question. Now, Milord, this clause must be read in the anvil of, Milord, 33. 33, Milord, kindly sees, which he says, the contractor, this will govern the classification, enlistment in UPSC, the tenders of only those contractors who convey any for in the UPSC limited who are enlisted tender for the work according to the contractor enlisted under any class shall be permitted to tender. 33, Milord, is in contradiction with 21 clause 19.
The original contract was
The original contract with
tender issuing authority is ESIC.
ESIC.
Right.
ESIC
He does not have a problem.
No, and the ESIC
You also have a problem.
Yes, my lord. So far the tender is concerned, Lordship, we have stated at page, Lordship will kindly come to page 50 of the.
You have a problem with
We have
UPSC?
not imposed any restriction. So
Yes.
simultaneously.
Why don't you take it up with your contractor?
Yes, my lord, since the matter is subject,
No, no.
that is the, because.
Oh,
yes,
no,
the
question is,
other
Milord.
violations of the contract
No, no,
also,
Milord,
Lordship.
possibly.
No, it
We
is
have not-
always up to you to take it up with your contractor.
my lord, since the
Why will
matter
the
is-
court permit a third party to raise all these issues?
I am not standing, but since the matter is pending before your Lordship for hearing, that is why we have.
Not hearing at your instance.
No,
my lord.
no,
my
Milord,
lord,
kindly
my lord.
seize
We
your
are also
lordship's first interim order. Kindly seize your lordship's first interim order. Interim order was passed on the basis of the submission made by him.
Yes, my lord, we have not.
Yes,
No, no.
yes. Then why
No,
do
no.
you
Then,
have
Milord,
a
so
problem?
Milord, today I am seeking the constitution. I am seeking a relief from a constitutional court. Kindly, Milord, allow me to place this. This is the only, Milord. This is a memorandum of understanding. Employee state insurance. Parties are bound by the contract. 37 of the Indian Contract Act.
Right. If the parties are bound by the contract, the parties are.
Parties means he and this gentleman.
You
both
are
the-
nobody.
No,
You are
I am nobody.
nobody.
I am affected by the decision. I am affected by the decision. Milord, only one indulgence. Milord, kindly give me. Milord, this exercise of power, the rule 33. Milord, that is absolutely contrary to.
Where is your stand over here?
Kindly
that you
ask
are
him to file an
also
affidavit. Why did he not
aggrieved
file?
by the stand of
He did not
your
file any
contractor?
affidavit.
Our stand is that so far the original tender is concerned, Lordship, we have not put any restriction.
Yes.
Vice versa, they are not being the contractor, they are not eligible to put any restriction on the.
Intimate it to your contractor.
We have already.
No,
intimated that-
Show me.
No, my lord, definitely I am not.
Kindly,
that
no, no,
instruction,
kindly,
Lordship,
Milord, ask
my
him to file a
specific
one-page
instruction
affidavit.
Now, my lord,
Kindly ask him
they
to
put a restriction.
No.
But they put a restriction. Kindly come to page 42. Let me accept
42 of
the writ petition. Let me accept both of the submission of both of my learned senior friends.
42.
We have to accept it entirely. Page 42, the tender notice for 2024-2025. May I read it for my lord? The competent authority of ESI Corporation, ESI Regional so-and-so invites on behalf of the Director General ESI Corporation online bid offer for sentence charges for eligible central, state, public sector undertaking, autonomous bodies for enrolling into the memorandum of so-and-so. So, my lord, this was the first one we participated. So, if we have to go by entirely, now no private body can entertain now? How could
No,
they?
yes.
If they want to implementation of this, but we are the person who got it. Now we have our own privilege to go. We shall not engage anybody who doesn't fulfill the criteria. The eligibility criteria that my learned senior friend already showed. We are going to engage those persons, those who have this qualification or this criteria. Who is he to intervene in this process? Rather, my lord, we are going to lose this tender by the next month.
No, I
am not going to interfere into anything.
Milord, kindly then, Milord,
The
ask them to,
matter
Milord,
relates to a notice
Milord, his
inviting
submission
e
may be recorded
tender
that he has
floated
That's from the
by
bar.
the Employees State Insurance Corporation being numbered 42 te number ta tule deben. The
Milord, the interim order was granted on the basis of the submission made by the government, Milord, the ASI.
the to participate in the said tender.
I did not
the
participate.
the now the tender was open from
Well, can you record
eligible
my submission that I have shown
central
you, Lordship?
slash state slash public sector undertaking slash autonomous bodies for entering into memorandum of understanding.
my lords, kindly.
Yes, for taking up the annual repair and maintenance of civil and electrical works and special repair works bracketed মধ্যে on need basis of all the buildings under the control of ESIC space দিয়ে আরো Kolkata, West Bengal and Sikkim for a period of 1 year. ঠিক আছে? Paragraph the Uttar Pradesh Small Industries Corporation Limited participated in the said tender and emerged successful. Stop. The successful bidder intends to engage subcontractor for performing the work and has limited participation only to the members who are registered with UPSIC Limited, Kanpur. Stop. The paragraph the petitioners are aggrieved by the same and have filed the instant writ petition challenging the restriction imposed upon by Uttar Pradesh Small Industries Corporation Limited. Stop. Paragraph. It appears from the submission made on behalf of the parties that that for being eligible to participate in the subject tender, the bidders should be either central or state or public sector undertaking or autonomous bodies. Stop. The petitioners does not qualify any of the above. Stop. They had the respondent number 3 not floated further contract for engagement of subcontractors, the petitioners. Now, the cause of action for filing the instant writ petition would not have arisen. Stop. Paragraph. It is absolutely between the tender issuing authority and the contractor as to whether a subcontractor can be engaged or not. No, it will be up to কি বললাম? Whether to go on for a further subcontract or not for performing the work. Stop. The
My lord, may I interrupt? My lord, as per the tender, we have entered into an MOU with the respondent number 326. There is a clause for engaging the contractor, subcontractor. That provision is also there, my lord.
Very well. It is up to you all.
We are engaging now. So far the subcontractor is concerned, there is no restriction that it must be from.
Yes, if they have imposed a restriction, you take steps.
Lordship, kindly record that their regulation does not provide for this condition barrier outside Uttar Pradesh. That is from the regulation it will appear.
In the event the successful tenderer does not fulfill the terms and conditions of the contract, it will be open for the tender issuing authority to take steps in accordance with the contract against the successful bidder. Stop. There is no scope to grant relief to the writ petitioner in this case. The writ petition stands dismissed.
Kindly record
interim order vacated.
that this
The
better is
interim
not
order
as per
stands
the
vacated.
regulations.
Good morning.
See, Lordship, kindly record that
What?
it is the barrier that
Yes.
he must be.
That will be in the next course of action. Yes, 7.
7, I appear on behalf of the petitioner.
Yes.
This was where bank was to take instruction as to whether.
Right.
refund the money.
Has the money been
Yes,
refunded?
refunded the money, my lord.
On 15th, we have refunded the money.
There's nothing remaining in the writ petition except my claim for interest.
My lord, that is not permissible, may not be permissible, my lord.
No,
Because, my lord, the
withheld
act
from-
says,
Lord, I
the
don't
rule says, my lord, the rule says, rule 9(5) specifically says that this money is liable to be forfeited. Only at the instances, my lord, requested, so we made us, so we also wanted to go forward. We also wanted to go.
See, the court has got nothing to do.
I'm not saying so. We also
If you
wanted to
hold
go.
on to it, then you will not be able to
My
move
lord,
forward, and he will also not be able to utilize the money.
So
it is for the benefit of all that this has been done.
My lord, this has
Are you really pressing?
Lord, I will.
Why? How
Consider-
many days the money was with them?
September, 3.5 crores. From September.
Then we
to
also have a
February.
right to forfeit, my lord.
At least what is at least what
We have
is
given
there-
this money without prejudice to your rights and
Bank-
contentions, my lord.
Bank would have given up this interest had I come up and made any.
We have, because, my lord, we have
But
not
then,
kept it any
possibly-
interest-bearing account. We have not kept
possibly-
it.
No, at least savings bank account.
No. We have kept it in our.
Been on the road.
I don't think I'll grant interest in this case because had the matter been kept pending and affidavits and everything, then
Very well. Very well.
so since they have exceeded and you have got the money back at least, please come. It has been submitted by the learned advocates representing both the parties that the amount deposited by the petitioners before the bank has since been refunded. Stop. The petitioner submits that the bank held the money from September till 15th of February 2025, and the petitioner ought to be paid interest for the same. Stop. Paragraph. Learned advocate representing the bank opposes the said submission and submits that according to the auction notice, the money was liable to be forfeited. Stop. Paragraph. Without entering into the dispute as to whether the petitioner will be entitled to any interest or not, as it appears that the money has been refunded, the court is not deciding the said issue. I keep it open.
My lord, we may deal with the property in accordance with law. That may be. my lord.
Interest?
No, not interest, the property in question. We may deal
Keep
with the
the
property.
point of interest open
my lord,
for
I
him
kindly do
to
not.
agitate
My lord,
before a competent forum.
No, my lord, kindly do not. Because, see, my lord, kindly see, under the rules, the money was liable to be forfeited. You have refunded at once. At once, without thinking it twice, my lord.
Only thing is, my lord, my instructions are to pay for some cost because of this 3.5 crores that was there, even if it's token. Because the bank withheld the money without any basis. At least it got me to court. One of my appearance fee also, if the client gets, it'll be something.
My lord, then I was also ready to argue on merit, my lord, upon affidavit. I was also ready to argue on merit.
Didn't have the title deed.
Without entering into a dispute as to.
Did you get back your title deed?
Not the title deed. So title deed, I don't have the title deed. I have nothing to get back.
Only for the money that we have returned.
The dispute as to whether the petitioner will be entitled to any interest or not, as it appears that the money has been refunded, the court is not deciding the said issue.
Said issue. Stop. The writ petition stands disposed of. It will be open for the bank to deal with the property in accordance with law.
Cost, your lordship, is not considered.
No, nothing.
Very well.
Yes. Call the next one.
For the Lord, in item number 8, I appear for respondent number 1 to 4.
Yes.
In 9, my lord, I am appearing for respondent.
For the
Respondent, my union office.
For 8, Lordship, I am appearing on behalf of state responses.
As last occasion, I have shown before Lordship communication dated 7th of February 2025. Paragraph 3, they said they are concerned with passport, travel documents, and police clearance certificate. But
1 minute. Mr. Chakraborty,
Yes.
what is the way out over here?
Milord, may I just suggest one thing?
Yes, please.
The issue involved in this present petition is regarding the clearance of visa. And that has to be done only on the basis of police clearance certificate. It is not within the domain of the passport authority to give such clearance unless the clearance is obtained, number one. Secondly, the immigration authority gave her an interview, and after the outcome of the interview, there was a subsequent documents were directed to be filed, and this has to be done by the immigration authority. Let the immigration authority be paid party for grant of visa. Because visa is not in the domain of the passport authority under the Passport Act. This is a misconceived application.
What about the police clearance certificate? It is the passport authority standing in the way.
Your Lordship is aware that police clearance certificate under the GSR is to be granted by the state government. The state government authorities are made parties here. And let the state government decide that issue. Let it be given to the immigration authority. Immigration authority will grant the visa. The problem will be solved.
The court's order is there, isn't it?
Yes. Now, kindly,
Please show the court's
kindly
order.
take up this one first.
Yes, I have seen.
The third paragraph.
Hmm.
This is issued by the deputy
Passport
passport
officer.
officer. He said that it may kindly be understood that this office is limited to only issuance of passport, travel document, and police clearance certificate. So they are connected with this police clearance certificate, which I am in need.
The passport authority has the machinery to grant police clearance certificate unless this is granted by the state government.
That's not my record.
Direct the state government to decide the issue. Problem will be solved.
There is no decision required. There is a court's order also. Where is that court's order?
Page 45.
Page 45 of the
Magistrate order, Tumal.
Yes, yes, magistrate's order.
Page 45. Dated 9th of July 2024.
9th July 2024.
Yes. The last 3 lines.
Finds no impediment to disallow the. Hence, the petition is considered and allowed with the consent of the learned. Yes. State.
Yes.
What is your submission?
Lordship, the only difficulty is that when there is a charge sheet filed against someone and the trial is pending, we are bound to give the information that there is a pending procedure. We cannot bypass the situation and give a clearance certificate.
You do not have to bypass. The court has already permitted, right? So there is no question of any further bypassing.
Lordship, that has already been produced.
The permission which is brought to your Lordship's notice, that is about no objection regarding going abroad. But this issue is now limited to the grant of visa.
Yes.
The visa is not being given to her on the basis of this adverse police report. And your Lordship is aware, the immigration authority took her an interview. I can show to your Lordship, kindly come to page 30. Page 30 of Annexure P4. Therefore, kindly ask the state government to give the police clearance certificate and expedite the same, and let the immigration authority consider the issue. The problem will be solved.
Thing is, say, as the matter is pending, the report will always be adverse. It cannot be that there is no matter pending. The matter is pending. The court has permitted. Your GSR permits. If there is a court's order, the petitioner has already filed an undertaking. Where is the problem?
No, GSR permits, your Lordship has seen, and that has been annexed in the writ petition also. That is only in regard to grant of passport, whether 10 years or 1 year, limited to this issue. GSR never talks about the grant of visa clearance. That has been annexed. Kindly come to that, GSR.
If you want the immigration authorities to be added, please add.
Kindly come to page 59 once.
Let us see how far they can travel and how far.
Kindly come to page 59.
Yes.
59 is order dated 10th of December 2024.
Yes.
It must previous writ petition where I challenge the notice for impoundment of my passport. Now,
the
kindly
impounding will not take place now.
kindly come to page 61.
61.
61.
Yes.
Something was mailed by this court. In the said report, the regional passport authorities would provide a chart for the last 1 year for all cases where police clearance was issued or not issued against the individuals having pending criminal cases.
That is next matter. He has it. He'll produce
Yes.
it. Very well. The immigration authorities. Give me the competent authority who is to be added. Who will be the competent
Milord,
authority?
kindly come to Milord, page 30, which was the notice by the immigration authority for interview, page 30 of the writ petition. Yes. Milord, officer in charge visa, Department External of Immigration Authority under the External Affairs Ministry. That will be sufficient.
And see page 30, you've showed at the middle of the page, I see police records, the Indian police clearance certificate from the regional passport office.
Yes, that I am asking for.
I am saying, I am submitting, your lordship referred to the GSR. Then kindly, once in the list comes to the GSR, that is has been annexed in the writ petition. That is annexed to the writ petition, page 66. What are the conditions? What are the conditions and jurisdiction vested to the passport authority? That is limited to grant of passport only. The clauses, different clauses, this 1 year or 2 years or all.
Right now, you are not taking steps to impound the passport.
No, that has been stayed by the order of Mr. Situation Group.
Yes, that is stated. Right. Now, the immigration officer.
Yes. Immigration officer, Ministry of External
Down in a
Affairs.
piece of paper and hand it over to your learned friend as to who is to be added so that he can add. And what about the next matter? Show me the list, please.
This is the report as well as
A copy to your learned friend.
I have already handed.
All right. Report by the regional passport officer and affidavit of service.
Just to serve him.
Yes.
First part is kindly come to page 9.
What is this?
The chart showing that those are the applications. Page 10.
The GSR 570 you have
annexed. We have annexed and secondly,
9.
So far as the withdrawal of the show cause, which is as page 9. In view of the order, we have withdrawn the show cause notice. And page 9 is the report for last 1 year in all cases where the PC.
1 minute, page 9. Yes, in this regard, please read. It is to apprise.
Sought from this office on affidavit a chart for last 1 year of all cases where.
1 minute, page 9. Please read third paragraph.
In this regard, it is to apprise that the PCC is once clear police report is obtained from the police authority in compliance of the Honorable High Court's order, a search is carried out in the online database where it is observed that total 149 cases are carrying pending police and criminal cases and PCC are not issued. The list of these 149 cases are enlisted herewith for producing before this Honorable Court and we have annexed the list.
So you are issuing the PCC?
We are not issuing. In all 149 cases, we have refused to issue the PCC.
No, but then you have the authority to issue the PCC.
Yes.
Now the Mr. Chakraborty is saying that the police clearance certificate cannot be issued.
I tell you a lot.
So absolutely
No,
confidence.
no, I have not said that. I have submitted that the police clearance report is issued only basis of the report of the state government. Because the passport authority has no machinery to guard the police inquiry into the matter and guard police clearance certificate. The order, twofold orders. One order of the criminal court permitting her to go abroad. That is not a police clearance certificate. Police clearance, there are other cases involved, I find from the records. So the problem will be solved since it is limited to grant of visa. Although there is no prayer for grant of visa. Prayer simpliciter in the writ petition is for granting police clearance certificate. Then direct the passport authority to grant police clearance certificate on the basis of police verification report latest. That will solve the problem.
But in nutshell, if you kindly allow me only 1 minute time. But
We have threefold service.
Use the microphone so that Mr. Chakraborty can also hear.
We have threefold service. First, issuance of
Is it working? The green light?
Yes. First, issuance of passport. Secondly, in case of after lapse, we can issue the renewal of passport. And these are the issuance of PCC is the miscellaneous service. Now, this police clearance certificate is not mandatory to travel abroad. It is for some of the countries who require PCC for grant of their visa. Like Argentina.
No, like now in this matter, there is a requirement.
Yes, there is a requirement. There is a requirement from the US consulate for PCC. Now, issuance of PCC is a system generated process where if find there is an adverse order or adverse report, our hands are tied.
So wherever the matters are pending before the criminal court, you get an adverse report.
Yes.
Right?
Yes.
In that case, nobody can travel to those countries where PCC is required.
Kindly appreciate one thing also. Kindly appreciate, this is not a case where the petitioner just want to go and meet with his fiance and come back.
Yes, this is the case.
No. Lordship, kindly see that she is applied for immigrant visa. Immigrant visa for she want to stay there. And that is the
undertaking is for 2 months recorded by your lordship.
I can show, my lord.
No, she is going to stay there for only 2 months.
For 2 months, there is no PCC is required. Kindly see their visa application. Kindly see once. Kindly come to. Oh, this is the. Kindly take item number 9, my lord. I have the brief of item number 9.
Let me see the file. Case number is 28965.
Yes, ma'am.
Item number 9.
896.
Yes.
My lord, kindly come to page 23.
Yes.
My lord, left hand.
Visa category.
Visa type immigrant. Now, what is immigrant? This is this is the immigrant visa from US Embassy, and he applied under the fiance category. This is kindly see.
Is the lady intending to stay over there?
No.
This is
Why has
she
the
applied
immigrant
for.
visa been applied for?
I have applied for fiance visa.
This is under the immigrant category. If she want to go there for 6 months, no requirement of PCC.
You limited in the visa?
We can't, my lord. We can't, because I tell your lordship, this is not our job. Kindly appreciate. She applied before, my lord, the US Embassy for immigrant visa. Now, US Embassy say that for immigrant visa, you require to submit PCC. Now, we are the authority who can issue the PCC subject to the report of the state government. The state government say that there is a criminal case pending, and as per our guideline, my lord, since the case is pending, our hands are tied. Now, if she want to go to the US for 2 months, she can apply for the tourist visa, B1, B2, no necessary for PCC visa. But she applied for K1, and that is for long-term visa, my lord. And that is the reason, my lord, PCC is required.
If they are so disabled, let
Granted
them
for 5 years and 10 years.
let them issue that NOC with a limited remark that I would be bound to come back with 6 months or 2 months.
The visa will be issued by the other country, not by India.
Let them limit my for the
They can limit.
let them limit my passport then. No issue. I want to come back within 2 years, 2 months.
But then why don't you change your application? That will serve the purpose.
But,
If under B1 and B2 you can get it, why go for K?
But let me kindly keep this matter pending.
Yes.
Let me take
It
instruction.
will remain pending. That
Yes, because I am applying. If even then I'm in requirement of this PCC, then I would have to face trouble. I'm ready to change, no issue, because I want to go there for 2 months only. There is no issue.
Because your submission that you are making in court and the document that your learned friend is showing, if these two are diverse,
Fiance visa, that's there. The fiance
No.
visa.
Education visa under the fiance category.
The fiance category is there. But
Maybe
if
its
they say for
category
tourist
is
visa,
there.
I have no problem. I shall apply for the same.
Yes.
Keep this pending, let me apply.
Your intention is to go, meet,
Only
come
for
back.
2 months.
Right.
Only for 2 months.
So you can apply in the category where
Yes,
there is PCC will not be required or something.
In terms of them. I'm not
Yes.
aware.
Mr. Chakraborty, is it all right if the category of the visa application is changed from K to B1, B2?
No, I have no objection, but the prayer is limited simpliciter to the grant of police clearance certificate, not visa at all.
Yes.
In the writ petition. That has
But then
also
the
been changed.
submission, today's submission is that if the visa type is immigrant, then PCC is required. If it is only B1, B2, then PCC may not be required.
That submission on instruction has come from Mr. Bhattacharya. I have no objection to that. Though your lordship can mold the prayer, no problem.
No, prayer we can mold, it's all right. But then I need proper instructions.
Yes.
If
I think
if the petitioner's purpose is served with a B1, B2, then she can always
Yes, suggest one thing, Malat. Let this
make suggestion to your learned friend.
let immigration officer be added as a party. He can
Give the details so that he can add.
Yes, so that he can enlighten on this issue, Malat.
Please come. Leave is granted to the learned advocate on record of the petitioner to plead the Immigration Department as party respondent in the instant writ petition and serve a copy of the writ petition and all other supporting documents. Supporting the connecting documents to the added respondent. Stop. Will 1 week be all right with y'all? Or you need some more time?
Now I'm not aware to whom I have to make party.
No, he'll give the name. Immediately.
Because immigration officer of the
Achha, list the matter on 5th, 2 weeks time for abundant caution. Call 10, please.
If my learned friend asks me to implement this concern general, the embassy.
No, not the embassy and all this.
That's the suggestion.
Give
only the
Immigration Department of the External Affairs.
Immigration Department have nothing to do with this case.
Now
Because the authority, the consulate who can issue the visa. Our immigration department has nothing to do with
from where he got this instruction that if it's transferred to PCR not required.
In that case, it will be difficult.
I tell you,
I will not direct the US consul and everybody to add it over here.
Kindly see the document.
Mr. Chakraborty, give me the name of the officer concerned.
As of now, I don't have the designation, but Immigration Department, Ministry of External Affairs may be made a party.
Immigration Department, Ministry of External Affairs.
I shall.
Mr. Bhattacharya, it will be from the Ministry of External Affairs only. Call.
If they says that tourist visa is enough, I shall convert.
Yes, what happened?
That partisan matter, my lord.
Yes.
Well, my lord, that biscuit matter, my lord, where the
Yes. Start resign.
Yes, my lord.
Lord, we have
What
acted
happened?
in terms of my lord's order.
The central
We have
office were supposed to file
collected
their
the
opinion.
new
What
batch,
is the
fresh
report?
batch, my lord, and my lord, we have sent it to the central lab.
Yes.
Now it is for them, my lord. We did not receive any response from them.
Yes.
For two respective petitions, which is 1912 and 1887. 1908, it's still pending from the.
All right. What is the report? Please circulate copies.
Yes, we are supplying.
Is it safe, unsafe, or what? It's safe? I am keeping this on record. And let the state government
Maybe go through and come back.
Yes, please.
If my lord deems fit, we shall file our opinion. My lord,
Yes.
take a fortnight's time to form an opinion because we have also received this report
I can
along with
fill
another report which is pending.
All right. So you'll get that also within a
May
fortnight.
we get a copy of this report? Copy to them. No, I can't.
A report by the director, referral food laboratory.
আমাদের 12 10 12 একই
Union of India कोई कुछ नहीं देना.
of the National Food Laboratory, Government of India, Ghaziabad.
यूनियन के हाथ में सब इधर है
Signed on 14th of February 2025 is taken on record. Stop. Let copy of the same be circulated to all the parties. Stop. Let an opinion from the Director, National Food Laboratory, with regard to the food products be placed before this court, clearly specifying as to whether they are safe for human consumption or not.
Your Lordship has already directed the respondent number 3 to give opinion.
Who is 3?
Respondent number 3 is the FSSI, the regional director.
Yes, he'll give.
Regional director.
Respondent number 3.
Respondent number 3.
Respondent
That
number
order was already
3.
there.
Respondent number 3 will forward. যেখানে বললাম
Laboratory has
director,
already gave their.
এই জায়গায় হবে respondent number 3.
may I only my lord my lord may kindly specify my lord our case is my lord this tartazin is allowed in cookies, it is not allowed in this particular biscuit.
How does it matter whether it is a
May
cookies
I-
or
my lord,
I
have
consume
got-
it through liquid,
I
I
have got the
consume it
question,
through
my lord.
solid
I have
thing,
got-
it goes in our body.
may I lord may I
Yes, yes.
specific না হলো my lord how many biscuits do we consume per day and how many cookies we do consume per day. This is the underlying distinguishing factor. The food safety standards have been set by the central government. They have allowed it in the cookies and not on the biscuits. They are the experts.
আচ্ছা আরেকটা জিনিস
My lord,
বলে দিন
that
তো,
is something which we are disputing, my lord.
it shall also be mentioned as to whether the
Tartazin, my lord.
Chemical.
My lord.
Whether
Additive, my lord. This is the food additive.
Acha, whether the food additive
Tartazin, my lord.
is within quotes tartrazine is permissible
Permissible in the specific biscuits which
in
we
the
have.
specific
in
biscuits.
the subject biscuit.
Subject
I'm
biscuits.
so very grateful. My lord. I'm
Right?
so very grateful.
That is the order. Your Lordship has already passed that
Right.
order on 31st January.
2 weeks.
Yes, madam.
List on 5th of March. Acha.
We are grateful, my lord.
The top is which item will be the top?
The top is, my lord, item number 12.
12. Then googly must be the
Google
other
the
one.
item number 10.
10. Item 10 এর ফাইলে এটা রাখবেন জানা বাবু আইটেম 10 এর ফাইলে এটা থাকবে আইটেম 12 এর ফাইলে এটা থাকবে
কোথায় গেল
and what is this somebody handed over compliance report
That
the
is
state of
the
West Bengal
state, my lord. That they have, my lord, sent the sample.
এটা হচ্ছে 1912 are there two reports compliance reports or one
one only, my lord.
there is the other one ওটা কোনটা
item number 12, my lord. I have
right so this 10 right ওইটা 10 এ থাকবে জানা বাবু 10টা এখানে আছে and this will be 12
11 minute, I will hand up, Lord.
coming 11 is coming
11.
আচ্ছা 11 এরটা 11 এ রেখে দিন 11 নম্বরের রিপোর্ট দিচ্ছে স্টেটের ওটা রেখে দেবেন 11 also will appear on 5th March. The opinion of the respondent number 3 shall be filed on the adjourned date.
Get hold of all the reports.
And, my lord, in between, they should also submit the report because that report is not there.
The report of the food laboratory shall also be placed before the court on the next date. ঠিক আছে
Lord, in the 11, my lord, on the last occasion, my lord, I have appeared, my lord, but inadvertently my name was not recorded.
11 নম্বরেতে
Item number in WPA 190822.
yes give your appearances please
And in
item number 10 আর 11 এ আগের দিনের appearance রেকর্ড করা হয়নি সেটা রেকর্ড করে দেবেন
And, my lord, in item number 10, my lord, the respondent should be respondent number 4. In other two petition is respondent number 3
আচ্ছা
because there is a 2A and in
Alright.
this petition is not there.
item number 10 এতে respondent number 4 হবে 3 এর জায়গায় ঠিক আছে অন্য দুটোতে respondent number 3 হবে এটাতে 4 হবে ঠিক আছে very well call 13
We are grateful, my lord.
Grateful.
1908.
Well, item number 39 for the state respondent. On the last occasion, your lordship directed me to take an instruction whether the car which is allegedly parked in the parking slot of DM or
government.
not. I have
Yes.
talked with the DM. My lord, report is awaited.
All
My
right.
lord, if your lordship can extend 1 day time, I shall get it. I
Monday?
just had a talk with the DM. He is sending me by mail.
All
My
right.
lord, if
So
it-
by Monday.
By Monday.
By mail, you can get it today only.
My lord,
Today is Wednesday.
My lord, your lordship asked
If
to hear out that effort we have to make from get a phone number of DM.
Very difficult. I
One
understand.
officer, he is asking me to pray time before your lordship. He instructed me what to do before your lordship, and very difficult. I had with the interference of London Advocate General.
Let me tell you one thing.
My lord,
On-
I suppose, my lord, it is an advocate of state advocate who is supposed to appear on their behalf has to face this type of what
I
a simple
remember-
man has to face.
On one occasion, I was directed, in fact, directed by one of the authorities to go to the office to collect the information.
We have
So
same
I know
experience,
what
my lord. I am
happens.
not opening my mouth since.
Acha, আসুন তো। On the prayer of the learned advocate representing the state respondents. List the matter on 24th February. Stop. The report from the DM's office shall be placed before this court on the adjourned date.
Grateful. But I tendered my apology.
No, it's all right. Nothing can be done.